It's not quite 2 o'clock yet, so we'll wait till everyone has an opportunity to get on the line before we begin. Good afternoon, Ms. Falk. How are you?
I muted. I'm doing well, Your Honor. How are you doing today?
I'm doing well. I got received Mr. Bartels' order that I've looked over. Was that okay with you?
I had an opportunity to look at it. Let me just give it a quick once over once again, but I think that's fine, Your Honor.
Okay, you can just tell me during the course of today.
Yes, Your Honor.
Okay, I won't sign it until I get your okay.
Judge, you waiting on me?
We're waiting on Ms. Gant from the PD's office.
It's number 5, right?
Yeah, that's correct.
And Your Honor, I had a chance to review it. That's fine.
Okay, thank you, Ms. Falk. Who else do we have from the PD's office this afternoon, excuse me. Ms. Bronstein, good afternoon.
Good afternoon, Judge. I also believe that Mr. Dale Coleman is helping out today too.
Okay, which cases are yours, Ms. Bronstein?
My cases are, I don't know the case numbers. Sorry, I joined helping kind of late, so
Okay, that's fine.
I have Mr. Jamal Ponder, Christian Osorio Garcia, Michael Shinholster, Dayron Williams, Ernest Trumbull, Lan NGO. I don't know how to pronounce her name. I know initially we asked for an interpreter, but I spoke with her and she is able to speak English and request that we go today without an interpreter.
Okay,
And
thank you.
Marilyn Walls.
Okay, thank you. Ms. Gann, are you with us?
Yes, Your Honor, I am.
Good afternoon. Good afternoon. We're on position number 5, Mr. Rico Brown.
Okay. Your Honor, I waived his appearance and am requesting a breakout.
Miss Gant, he told me that he wanted to see the judge, so that's why only reason why I brought him back.
Okay, duly noted. Duly noted. I apologize.
I've been medically cleared. I had high blood pressure. I had to go to the
Okay, Mr. Brown, I ask that you remain silent.
Wait a minute.
Okay, what cases are we gonna need a breakout for today, please?
The remaining case for me, Your Honor, is Mr. Colbert.
Give me position numbers if you would.
Let me see.
That's position 8. Any others that we're gonna need a breakout for?
No remaining breakout requests for me. Thank you.
And
Good
Judge,
morning, Your Honor. Oh, I asked you afternoon.
Good afternoon, Mr. Coleman.
I have a client I'm going to need to speak to with a Spanish interpreter, Mr. Lopez. He's position 19.
Okay. Thank you. We'll see if we can get him in a different room to give you a breakout at some point.
All right, thank you.
We've got a number of people on the calendar, so I want to try to.
And Your Honor, if I may, I do apologize for interrupting again, but I have not interviewed, let's see, this Mr. Burdett. Let me tell you his position.
He's on the way, Ms. Grant. I know that's the last person you need to interview.
he number 6.
Number 6. Okay, thank you, Your Honor.
Okay.
And Judge, Rico Brown got a total of 136. So I'm sure you kind of know where they're going with this.
Said medically cleared of important.
All right, so Mr. Brown's appearance has been waived by Ms. Gant. So if we can go to the next person, please.
They don't make that. So we medically cleared of release.
Courtroom 2, did you hear me?
Come on, Mr. Brown.
What was that, Judge? I'm sorry.
Mr. Brown's appearance has been waived by counsel today, so we'll take him up later if we can go to the next position.
Your Honor, I haven't been in court within 72 hours to see my attorney beforehand of a list of a contention.
I understand, Mr. Brown. We'll have Ms. Gant speak with you. Thank you.
I'm sorry. Now we can go to position number 15, Mr. King, please.
Who's representing Mr. King?
Good afternoon, Your Honor. That would be me, Gerald
Okay.
Coleman.
Thank you, Mr. Coleman. Good afternoon, Mr. King. I'm Judge Eric Morrow. You have been charged in case 22 CR 002136D with criminal trespass and fare evasion. Is there a history, Mr. Howard?
21 total. Last arrest was in February, probation violation.
What's the total again?
21. On probation for felony obstruction, fare evasion, trespass, simple battery as well, out of state court. He also has history out of state in the state of South Carolina for larceny, disrupting public schools, drug possession from 2012. He was arrested December 2021 on MARTA for trespass, obstruction, simple battery. 2019, simple battery against police, misdemeanor obstruction. He had a terrorist threat that was amended to a non-fingerprintable charge from 2019. That's it.
Good afternoon, Ms. Webb. Is this your case?
Yes, Your Honor, it is. I apologize. It's taking me a second to find the mute button. Yes, Your Honor, it is. In this particular case, the state is going to request a $1,000 surety for the trespass with a $500 surety for the fare evasion with a stay away from the MARTA West End station located at 680 Lee Street, Atlanta, Georgia. No alcohol, drugs, or weapons. Your Honor, this incident did take place on April the 8th at that Lee Street West End MARTA location where the defendant was found pushing through the pavement gates and fare gates. Your Honor, the defendant does have an active year-long or 365-day-long MARTA suspension that was issued on October the 14th of 2021 and doesn't expire until November 14th, 2022. He was also issued that effective date of that previous notice was November 14th of 2021, stemming from an incident that occurred on October 14th, 2021. Your Honor, as you've heard from pretrial, the defendant has another open case for similar offenses at another MARTA station, Your Honor. And here we are just merely this is the second incident in 6 months, Your Honor, and he has already violated that notice to not return it to stay away from MARTA property. For those reasons, Your Honor, the state is requesting that $1,500 total surety bond with the stay away from all MARTA property and no alcohol, drugs, or weapons while on bond. Nothing further.
Mr. Coleman?
Your Honor, I will be requesting a signature bond from Mr. King. He is 33 years of age, a resident of Atlanta, Fulton County. He went as far as the 10th grade. He's currently employed at Staff Zone Temp Services. He has little to no money to post for bond, no children. Again, I'd be requesting a signature bond on lieu of that a low bond from Mr. King.
Your client has his hand up, Mr. Coleman.
Yes, sir.
I understand that I don't supposed to be at MARTA, but
So I'm not going to ask you not to speak about the facts of the case at this time.
Okay, it's going to be a $250 good bond for each charge, making it a total of a $500 good bond. Stay away from MARTA, no drugs or alcohol while out on bond. Good luck to you, Mr. King.
And what is the SAP reset date?
The SAP reset date is going to be April 26th.
April 26th. Thank you.
Yes, thank you. All right, good luck to you, Mr. King. Who do we have next? It appears courtroom 2 is frozen.
Hey, I'm sorry, the Zoom link keep freezing up and it's messing up the service, so can we repeat for Mr. King, please?
Yes.
He has a $500 good bond. His reset date is going to be April 26th.
Thank you. Position, Mr. King.
Like saying I want to fuck, I want to speak for my own fucking self. Fuck.
Okay, we'll try this again. Position number 1, please. I'm sorry, Mr. Anderson.
Thank you. You're fine. Good afternoon, Mr. Anderson. I'm Judge Eric Mora. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002155G with battery family violence. Is there a history, Mr. Howard?
26 total. Last arrest was 2013 parole violation. Before that was 2013 possession of cocaine conviction. 2008 felony theft by receiving, giving false statements, possession of a firearm by convicted felon, a felony first offender arrest. 07 false imprisonment conviction. It was a capital case. With that, it was not presented to grand jury. That's enough.
Okay. Good afternoon, Ms. Duncan.
Good afternoon, Your Honor. How are you today?
I'm well, thank you.
In this case, it's pre-trial stated. The defendant has about 25 cycle. I have that the defendant has 20. We're on. My apologies. Are we on Anderson, Your Honor?
Yes, position 1, Dwayne Anderson.
Okay. I have Anderson with 25 cycles going back to 1991. They include convictions for carrying a deadly weapon at or to a public affair. And most recently, I have possession of cocaine in 2014. The facts of this case is that the defendant ran over the victim's foot with his car. The victim in this case is Shannon Milner. Shannon, common spelling Milner, M-I-L-N-E-R. The state has a concern in this case about intimidation of the witness due to the fact that the victim and the defendant do live together. And as Your Honor is aware, in the cycles of violence, shelter can be used as a means to dissuade a victim from participating in prosecution. Given the defendant's history, we've called the victim and we weren't able to make contact due to the nature of this offense. We are concerned about the safety of this victim. We're requesting a $3,500 surety. No further contact with the victim in this case. Third-party child contact, if any children are between the two. Stay away from the incident location of 2929 Landrum Drive Southwest. One-day anger awareness. No alcohol, drugs, or weapons.
All right. Is this your case, Ms. Gant?
Yes, Your Honor. Mr. Dwayne Anderson is 50 years old. He has been in the Atlanta area his entire life. He has family here, including his 8 kids, the oldest of which is 31. We are opposed to the stay away at 2929 Landrum Drive. Mr. Anderson informs me that that is his residence. And Mr. Anderson completed high school. He has a 2-year certification in HVAC. At this time, Your Honor, Mr. Anderson is unemployed and has been so for over a year. He is on kidney dialysis and he must go in to receive treatment to help his kidneys actually have a machine to do what his kidneys would normally do. Therefore, being in jail would just not really be in the best interest for his health. I did reach out to Ms. Miller. She has not given me a call back. Mr. Anderson states that he is unable to pay anything toward bond. I do acknowledge my client's history. However, I believe the last thing that I heard was back in a probation violation in 2013. That's almost 10 years ago. And then, of course, in 2013, we heard about cocaine possession and theft. I did not hear about anything significant in the areas of violence. Therefore, Your Honor, I am requesting a signature bond on Mr. Anderson's behalf. And if Your Honor is not inclined to grant a signature bond, then the lowest bond possible. Again, we would like to have contact, but given that we haven't been able to reach out to Ms. Miller, I would defer to the court's ruling regarding no further contact, the third-party transfer, and would ask Your Honor that being that this is his residence, Your Honor, that he be granted a one-time law enforcement escort to confirm whether or not Ms. Miller still is there.
Okay, it's going to be a $5,000 signature bond through the jail. No further contact with Ms. Milner. Stay away from the Landon Drive address. You can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Anderson.
All right, thank you, Your Honor.
Position number 3 is next, please. Balkman.
Position 3.
Yes.
Good afternoon, Mr. Bachman. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You've been charged in case 22 CR 002157F with battery. Is there a history, Mr. Howard?
29 total, between Georgia and Florida. Last arrest was October 2021. Possession of a Schedule II controlled substance. Misdemeanor possession of marijuana. It's 21 CP 204010. January 2021, probation violation. 2019, possession of meth. Possession of a Schedule I controlled substance. Possession of a firearm by convicted felon or felony first offender. It says unlawful for any person to purchase, possess, or have under his control any controlled substance. So that's another count. 2016 probation violation, another 2016 probation. 2012 as well. 2012 simple battery family violence. It was amended to disorderly conduct conviction. And before that was 07 parole violation.
Was the 2021 parole violation, was that for the 2019 meth?
It doesn't say.
Okay,
It don't have an underlying charge on it.
all right. Who's representing Mr. Bachman?
I am, Judge. Good morning.
Good afternoon, Mr. Lewis. Go ahead.
Good afternoon, Judge. And I apologize. I did not hear the criminal record. I heard Mr. Pretrial reading it out, but I wasn't attentive. The gist of it, Judge, I understood he had a couple of violations of probation of parole. What felony charge was he convicted of?
I think possession of meth. Is that right, Mr. Howard?
Hold on.
Oh. Judge, come back to me, please. I'm experiencing some technical problems right now. Can you come back to this case after your very next one? Who's power?
Courtroom 2, can we go to the next person, please?
that's
We're gonna come right back to Mr. Bachman. So
I'm ready. I'm ready, Judge. I got
Ready?
the problem resolved. We can stay with that person if you want to.
All right, so to answer your question, in 1990, he was convicted for drug possession. They gave him 6 years to serve and 24 years probation. So that's 30 years total. So that's where that come from.
Okay.
All right.
Thank you. That's what I needed to know, Judge. So you heard about this client's vast array of criminal records. If I heard Mr. Pretrial right, it was in 1990 that he got his felony case. Judge, he is 63 years of age. He is a lifelong resident of the state of Georgia and has a residence on Peachtree Street, North Atlanta, Georgia. He has an apartment there.
Your Honor,
He doesn't have a telephone.
I'm sorry to interrupt
but
Mr. Lewis, but I don't think the state has actually made their proffer yet.
Oh, I'm sorry. Go right ahead then, State.
You're right, Ms. Falk. When I was asking for who counsel was for Mr. Lewis, we went into it. So hold on for me, Mr. Lewis. Ms. Duncan?
Yes, Your Honor. In this case, as pretrial stated, this defendant has 23 cycles total, 6 out of Florida, which include 2 drug convictions. He is a multi-state offender and a convicted felon. In this case, Your Honor, officers arrived on scene of Unit 2505 at the location of 355 Peachtree Street Northeast. And he approached the defendant in this case. Let me first start by saying that this is a cross defendant case. So for this charge, its bond is currently set at $10,000 surety. On April 9th, 2022, at about 6:46 a.m., officers were dispatched to the location as stated previously. The defendant approached officers' vehicle and told them that he was attacked inside of his apartment by a female acquaintance who is the cross defendant in this case, in this incident. He stated to officers that she came to his home to retrieve money for services she had rendered to him at the time, and she asked to go to the restroom, and he observed her while she was going to or coming out of the restroom, and she went into his top drawer and took what he says is his rent money. When he confronted her about why she was taking his rent money, according to the facts, she picked up a glass ball paperweight off the table and hit him in the head, and apparently bit his right arm. And they began to tussle, and he escorted her out of the apartment. And those are the facts in terms of this incident, Your Honor. As the victim would be Miss Stacy Lofton. That's Stacy, Stacy Lofton, LOFTON. Given the nature of the offense charged and the defendant's history, we would request, and also I would like to add, apparently there's open 21 CP 204010, 2 charges of possession of controlled substance in Schedule 2, which is felony, and a charge for obstruction and operation of a motor vehicle with expired license from October 23rd, 2021. Given those facts and circumstances, we'd ask for the bond to remain the same, no further contact with the victim in question, no alcohol, drugs, and weapons, 1-day anger awareness.
I'm sorry, Ms. Duncan. What did Mr. Bachman allegedly do to Ms. Lofton?
What he did to her, the facts indicate that he hit her in her head as well. I'm trying to find the name of the object. What essentially happened is they both hit each other in the head, causing lacerations and bleeding to each other. So there was a verbal altercation about the money, and then there were hits thrown by both parties. and he hit her in her head, causing a laceration by her left eye and bruising. He hit her in the head, with a pan a couple of times and caused a laceration on her head.
Who allegedly hit the other first?
It is unclear, given the facts and as stated in the police report, who was the primary aggressor. It was just noted by the officers that both parties attacked each other. Of course, as these situations of mutual combat go, each party is going to claim that the other is the primary aggressor. But what I can say is that this defendant, Mr. Balkman, did hit the victim in her head several times with a cooking pan, causing a laceration and bruising to her head and face.
And it's
Along with the
355 Peachtree Street. Is that Mr. Balkman's address?
That is his address.
Okay, thank you. Ms. Lewis?
Okay, Judge, I'm asking the court now to hold on this case because now I know who the state is alleging as the cross defendant is. So Judge, what you don't know is my mother's last name was Lofton. And before today, I have represented a person whose name sounds very similar to the cross defendant in this case. So I'm going to ask the court to hold for just a minute. Let me investigate whether I've got a conflict and then return back to this matter.
Okay, let us know, Ms. Lewis.
It doesn't happen all the time, Judge.
No, I understand. Courtroom 2, who do we have next?
I'm sorry, repeat, please.
No, I'm asking courtroom 2 to go to the next person.
Position number 27, please.
You done?
No, they gotta come back to him.
All right, who's representing Mr. Ponder?
I am Judge.
Oh,
Ms. Ponder.
I'm representing Mr. Jamal Ponder.
It's the male.
Okay.
Yes,
Yeah,
Jamal Ponder.
Your
Ms.
Honor,
Weinstein?
just to clarify, there are two Ponder cases. They are co-defendants.
Okay, thank you. So we have Jamal Ponder and Janetta Ponder. I take it this is Jamal Ponder.
Yes, Judge.
Okay, and that's Ms. Bronstein's client.
Yes.
Okay. Good afternoon, Mr. Ponder. I'm Judge Eric Morris. This is a state court expedited accusation calendar. You have been charged in case 22 CR 002148Y with willful obstruction of a law enforcement officer. Is there history, Mr. Howard?
11 total. Last arrest was 2020, battery family violence. The case number is 20 CP 189886. Before that was February 2020, abandonment of dependent child. 2017 misdemeanor obstruction arrest. 2017 probation violation for driving. 2016 same thing. 2016 trespass, ag battery. Failure to appear was NOD. And 05 drug possession. That's it.
Was the aggravated battery a conviction?
It just shows as an arrest.
Okay.
I didn't look it up. State may know.
Fuck.
Yes, Your Honor. So the facts that I'm going to give the court are going to apply to both Jamal and Janetta, just so the court's aware. So this occurred on April 10th, 2022. Officers responded to an illegal block party in the area of Arlington Avenue and La Rosa Terrace in Atlanta, Georgia. There were approximately 100 people on the street, an excessive number of vehicles that were parked illegally. So as a result, so that vehicles could actually get through that area, officers called out tow trucks to have the illegal vehicles removed. While towing a car, the co-defendant, Janetta Ponder, came out, began yelling at the tow truck driver, saying F you, and throwing a large cup of alcohol into the truck, striking the tow truck driver in the face. Officers then moved to place defendant Janetta Ponder under arrest, but she began pulling away and flailing and kicking at the officers, Officer Ruffin and Officer Roberson. Defendant Jamal Ponder then began pulling Janetta away from the officers, and so he ended up as arrested as well. So they were both arrested for obstruction. Miss Ponder, because she threw a cup of alcohol at the tow truck driver and then resisted arrest when she was kicking and flailing at the officers. And then Mr. Ponder was arrested because while the officers were trying to take Miss Ponder away and take her to the jail, Jamal Ponder then intervened and tried to pull her away from the officers, which then hindered their arrest. Additionally, this kind of really got out of hand. A number of people gathered around the officers, approximately 20 or 30. The officers had to deploy their taser as well as OC spray to get the crowd to disperse because they were crowding in on the officers. And in addition to Mr. Ponder, other individuals were also trying to pull at Miss Ponder. Mr. Ponder was the only one they were really able to identify after everyone dispersed. The recommendation on this case, Your Honor, we are showing that he has a 2016 probation violation from Cobb. That aggravated battery was reduced to battery. So that 2016 case, aggravated battery, was reduced to battery and criminal trespass. And he was convicted on August 4th of 2017. He currently, we're showing, has a bench warrant for an obstruction of a law enforcement case from 2017 here in Fulton County. And he has an open family violence battery case from 2020, also here in Fulton County. The state's recommendation on this case, he currently has a $2,500 surety bond. We are recommending that bond be reduced to a $1,500 surety bond with no alcohol, drugs, or weapons.
This is neither here nor there, Ms. Falk, but why wasn't Ms. Ponder charged with something for striking the tow truck driver?
Your Honor, to be perfectly honest, I'm not sure. So I am going to follow up with the officers to find out. It could have been something as simple as the tow truck driver did not wish to press charges, but I will discuss that with the officers to find out why she wasn't charged for some sort of disorderly conduct against the officers. I mean, against the tow truck driver.
Okay. Thank you. Ms. Bonstein?
Thank you, Judge. Mr. Ponder is 39 years old. He lives in Atlanta and he's lived here his entire life. His whole family is here, mother, siblings, aunts, uncles. He has 4 children, aged 14, 12, 9, and 6. He is a high school graduate and has a technical degree in maintenance. And he works as a forklift driver and he's been with his current company for 6 months. For the criminal history, it appears that he does not have any felony convictions. I didn't see any holds in Odyssey. As the state said, it's my understanding that this was a block party and he saw his sister getting arrested and didn't know what was going on. And he did get pepper sprayed. He went to Grady afterwards. It's my understanding that he got pepper sprayed and went to Grady and then was transported from Grady to the jail. Taking all that into consideration, he did want me to request a signature bond from the court. If the court's not inclined to do that, we would ask for a good bond not to exceed $1,000.
Okay, $1,000 good bond. No drugs, alcohol, weapons, or out on bond. Good luck to you, Mr. Ponder.
We got to position number 12, please. Throw that cup away. Thank you. Thank you.
Good afternoon, Mr. Ladrick. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002173G with 4 counts of theft by taking. Is there a history, Mr. Howard?
Yes, sir.
43 total. Last arrest was July 2021, probation violation. He has open suspended license, DUI, possession of a controlled substance. DUI of a controlled substance, I'm sorry. Regular DUI, failure to maintain lane. He has a lot of driving in his history. Theft, I saw a burglary, entering auto, shoplifting conviction from 2012, along with some probation violations. I see a 2011 simple battery arrest, shoplifting conviction 2010. That's it, Judge. I mean, related to theft anyway.
Ms. Webb?
Yes, Your Honor. This incident took place on November the 4th, 2021 at the Wild Wing Cafe located at 5530 Windward, that's Windward, WINDWARD Parkway, Alpharetta, Georgia, where the Alpharetta, Georgia Police Department investigated a report reported by the Wild Wing Cafe staff that the defendant allegedly stole items from that location as he was patronizing that business, Your Honor. The defendant is alleged to have stolen an iPad, an Apple iPad, a Dooney and Burke wallet, another wallet of an employee there, and $1,200 in cash from one of the employees who was on staff that day at the Wild Wing Cafe. Your Honor, our office did make contact with one of the victims. And just to be clear, each of these charges does involve a different victim, Your Honor. One of the victims did inform us that the defendant was not a former employee. As far as her knowledge, she doesn't know of him having anything or being at that restaurant previously, but that he was just a random patron. And our office is still conducting an investigation to find out the specifics of the matter as to how the defendant was able to access these items, Your Honor. But the defendant does have a present $6,000, am I correct? $8,000 preset surety bond for each of those charges, but the state is requesting a $4,000 surety with $1,000 per count with a stay away from the incident location, as well as no alcohol, drugs, or weapons, Your Honor. In this particular case, we are concerned with risk of reoffending. As you've heard from pretrial, the defendant does have previous theft convictions in which he has committed several probation violations since that 2012 conviction, Your Honor, for that burglary and entering auto. In addition, Your Honor, we are concerned that he's a possible flight risk as he has FTA previously on a Fulton County case in 2013. One of the victims are present or is present, on the line, Your Honor, and wishes to speak. Nothing further.
Y'all hear me?
Yes, Ms. Graham-Dixon, I'll be with you directly, okay? So if you just sit tight for me, I'll be with you, ma'am.
Yes, sir.
Okay, Ms. Gant?
Thank you, Your Honor. Mr. Levac is 36 years old. He is a Georgia native. He has been in the Atlanta, he returned to the Atlanta area from Opelika. He has been here for the past 3 months, Your Honor. He doesn't have much family support here. We are unopposed to the stay away. Mr. Levac completed high school. He also has an associate's degree, and he is working toward a master's in data science out of Boulder, Colorado. It's an online university. Your Honor, Mr. Levac is unemployed and has been so for the past 4 months. He's devoting most of his time to his studies. He is seeking, however, some part-time employment. He denies the allegations. And while I acknowledge my client's background, I would bring to the court's attention that the last we heard in the areas of theft were 2012. That's 10 years ago, and the FTA was 9 years ago. Given my client's inability to pay anything toward bond at this time, I am requesting a signature bond, Your Honor, as he is unable to pay and does not have any family support. And again, we are unopposed to the stay away. Thank you, Your Honor.
Ms. Graham-Dixon, now if you would like to speak, I'll need for you to raise your right hand for me.
Yes.
You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right. You can put your
Yes,
hand
sir.
down, ma'am. What would you like to tell the court?
Well, I would like for him to have to pay the bond because he stole money and he made an inconvenience to many people at my job, including myself, another employee, guests. And I actually have a witness that saw him reach over the bar and take my wallet from behind the bar. We have multiple witnesses that saw him in the station where the Dooney and Burke wallet was. So there's no question that he didn't take it. We have a witness that says they watched him. They didn't watch him take the wallet, but they watched him grab an iPad. They watched him reach behind the bar where my wallet was sitting, where the iPad was sitting. So there's no question that he didn't take it. But there's been such an inconvenience. I had to get a new license, new carry permit, money for my down payment on my car was taken. And I think he should have to pay that in order to get out of jail.
All right. Thank you, Ms. Graham-Dixon. Anything further, counsel?
Your Honor, if I may, at this point, these are just allegations at this point. He does enjoy the presumption of innocence. Thank you.
All right, it's going to be $1,000 good bond for each charge, making a total of a $4,000 good bond. Stay away from the Wild Wing. No drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Levick. You also, Ms. Graham Dixon. Thank you for being here.
Okay,
And
thank
I'm
you.
ready for you, Judge, when you are.
Who do we have next?
Position number 6, please.
Good afternoon, Mr. Burdette. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 00216-2F with battery family violence. Is this history, Mr. Howard?
His fifth arrest. 2017 was the last for DUI. That was a conviction out of Henry County. Another 2017 arrest for DUI. He played a NOLO. Hold on. Got history out of the state of Maryland. 06 larceny. 2016. It says act as a contractor without a license. Failure to perform contract. Those were dismissed. He's wanted out of Henry County. The charge is for simple assault. And the date of that one is February 1st, 2022. That's it.
Ms. Duncan?
Yes, Your Honor. As stated by pretrial, the defendant is currently wanted on an outstanding warrant for simple assault. And that warrant for simple assault is for the same victim in this case. The victim in this case is Kimberly Burnett, Kimberly common spelling, Burnett, Burdnette. She is the present spouse of the defendant. In this instance, Your Honor, on April 10th, 2022, officers were dispatched to the location of 860 Lake Forest Circle in reference to a domestic dispute. When officers arrived, they were met with Miss Burnett at the front door of the residence, and she stated that her husband, the defendant, was intoxicated and damaging things in the basement. Miss Kimberly went on to inform officers that the defendant in this case came home after drinking alcohol and hit her multiple times with his fist, causing visible purple bruises to her face, thigh, and arm. She stated to officers that he came home belligerent and intoxicated, and he consumed roughly 4 pints of Smirnoff vodka. She showed officers a video of the defendant forcing his way through the bedroom door and assaulting her. She stated that the defendant obviously, well, as stated before, he was in the basement. Officers actually found him unconscious on the floor in the basement, and he was smelling strongly of alcohol. Once he began to awaken, officers tried to get him to respond, but he was so intoxicated, according to officers, that he was unable to respond. So EMS was called to ensure that there was not a separate medical emergency, and they requested ambulance response. Then he was, they were given the information that he tends to become violent when intoxicated, so they handcuffed him. But when they attempted to have him stand up, he could not stand up, so they placed him in a chair until EMS arrived. And they tried to talk to him, but he was just too intoxicated. The wife indicated that he had previously been released from rehab, and Your Honor, he is a military veteran. However, it was indicated that he had been discharged from the military for his excessive drinking. We did make contact with the victim in this case, and she stated that she wants no further contact with the victim, with the defendant, my apologies, and she would like him to have a one-time escort to receive his belongings, third-party contact for the children. Your Honor, I just want to further indicate that the intoxication level was so severe that officers had to take this defendant to the hospital to receive treatment, and he had to be held in custody until he was able to be taken to the jail. Given the facts and circumstances surrounding this case and the nature of the offenses alleged, the state is requesting a $3,500 surety bond, no further contact with the victim, third-party contact with the children, a stay away from the incident location, 1-day anger awareness, no alcohol, drugs, weapons, and an ADET.
Ms. Gant?
Thank you, Your Honor. Mr. Jeffrey Burdett is 48 years old. He has been in the Atlanta area his entire life. He has been married for 1 year with Ms. Burdett. He informs me that they do not have any children together, therefore we do not need a third-party transfer. Mr. Burdett actually wants to continue having contact with Ms. Burdett, and of course I have not had the occasion to speak with her, and I understand that she will be on the call, so we will defer to the court's ruling. Mr. Burdett completed high school. He also has 1 year of college at the Art Institute where he studied visual communications. He is self-employed, and yes, he did serve in the military in the Marine Corps for 4 years. Mr. Burdett denies the allegations. He actually doesn't recall much about what happened that day. I acknowledge my client's history, but however, it appears that it is primarily for driving offenses, and there is an open case in Henry County. However, he is presumed innocent in that case as well as this case as well. We are unopposed to any no contact. And well, let me back up. After we've heard from, we will defer to the court's ruling regarding contact to stay away. And if there is a stay away, we would ask for a one-time law enforcement escort. I am requesting a signature bond on Mr. Burdett's behalf, given that he does not have any recent convictions or any convictions that I heard for violence, so that he may deal with the foreign county hold in Henry County. Thank you, Your Honor.
Ms. Burdett, I see you on the line. If you would like to address the court, I'll need for you to unmute yourself and I'll have to swear you in. Raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. What would you like to tell the court, Ms. Burdett?
My husband is a brilliant man, but he is needing at least a year or a couple of years in rehab, where he cannot talk his way out of it, or where he needs a mental evaluation as well. And
yeah, I would object to this testimony and ask that Ms. Burdett speak to her wishes regarding contact. She's not competent to testify regarding my client's mental health needs.
And the state would ask that the victim be able to testify as it is relevant to the other factors in the case.
Go ahead, Ms. Burdett.
Yes, sir. So I think he needs a mental evaluation and to deal with what happened in the childhood years, and rehab where he can't take himself out of it or walk out of it.
Okay, and tell me what happened on yesterday.
Okay, so he came home intoxicated, and I was actually at the lake fishing, and he got very upset because I walked away and I was on the phone with a friend, and he I told him, I said, look, I'm just going down here to close the gate, and I came inside. He was so intoxicated that he didn't really make sense. He was swaying. He was talking underneath his breath. Where we stay at, they kind of separated us because we started arguing about his drinking and him drinking and driving. So I went outside and took the spark plug out of the vehicle. So when he does try to crank the car, he wouldn't be able to go anywhere. I was actually upstairs laughing at jokes that were told to me. And when I was on the way down, I was laughing, and he came out, and I was trying to go in to get something out of the room, and he attacked me and hit me 2 times.
Were you the same alleged victim as this simple assault back in February 1st of 2020?
Yes, sir.
Okay. Anything else, ma'am?
No, ma'am. No, sir.
All right, anything else from council?
Nothing further, Your Honor.
All right, it's going to be a $3,000 good bond, no further contact with Kimberly Burdette. Ms. Burdette, I take it that you all don't have any children, do you?
No, sir.
Okay. He can have a stay away from the 860 Lake Forest Circle address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond. All right, good luck to you, Ms. Burdette. Good luck to you, Mr. Burdette.
Thank you.
Who do we have next?
Judge, could we do the breakout session with courtroom 3, the interpreter?
Yes,
We can
thank
probably
you.
do Mr. Coleman first, so
Okay.
I can keep doing Ms. Grant cases.
Okay, very good. Thank you.
Okay.
So in courtroom 3, we have, who do we have in courtroom 3?
I have Mr. Lopez.
Mr. Lopez, and Mr. Lopez's attorney is Mr. Coleman.
Yes, I'm here.
Okay, so Mr. Coleman, you need to speak with Mr. Lopez, I take it?
Yes.
Okay, Madam Interpreter, good afternoon. I hope you're well. Okay, so let's put Madam Interpreter, Mr. Coleman, in courtroom 3 into a breakout room, please.
Very well, Your Honor. Thank you.
Yes, thank you. And we will go back to courtroom 2, and tell me again, who do we have?
Can we go back to position number 3, please?
Okay, Mr. Lewis, did you work out your conflict?
I did, Judge. I do not have a conflict with this particular person.
Your Honor, if I may,
Hold on. Mr. Lewis, you do not have a conflict? Is that what you said?
That is correct.
Oh, okay, all right. And Mr. Lewis, you're going in and out on us, so I don't know if we need to get to a better place so that we can hear you.
Go forward or backwards. Okay, Judge, I'll do that right now.
Okay, thank you. Ms. Duncan?
yes, Your Honor. I believe that initially when I stated the state's position on bond, I requested that it remain set at
10,000 good?
10,000 good. My apologies. I would like to amend that. That was an error. We would like a $6,000 good bond, Your Honor.
Okay.
That's good, right there.
All right, you with us, Mr. Lewis?
Yes, Judge, are you able to hear me well?
Yes, I can hear you. Go ahead.
And I'm sorry, Judge, let me just make sure
We can't hear, Mr. Lewis, you're going in and out on us.
we're talking about.
You're going in and out on us. I can't hear you. Mr. Lewis?
How about
No,
Judge?
it's not good. You're gonna have to find a better place. So I'm gonna go on to the next person until we can get you in a better location. Who do we have next? I apologize, Mr. Baughman.
We have position number 26, please. Or so far, I don't know, I pronounced the name wrong. What's your last name?
Osorio Garcia.
Oh, sorry, okay. Position number 26.
26, Mr. Osorio.
Yes.
Good afternoon, sir. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002147E with driving under the influence of alcohol less safe. Is there a history, Mr. Howard?
Yeah, first arrest.
Ms. Falk?
Yes, Your Honor. This incident happened on April 9th at 3:21 a.m. Officers were patrolling the area of Holcomb Bridge Road and Caliber Creek Parkway in Roswell. The officers observed a white Dodge Ram that had been stopped on the roadway. They then saw the defendant walk over to the right side of the truck and was stumbling as he was looking at what appeared to be damage to his tires. Officers made contact with the defendant. They smelled the strong odor of alcohol coming from his person. And what they also observed, which was particularly troubling in this case, is the right side of the defendant's tires. The entire right side of the truck's tires were destroyed to the point that there wasn't even sidewall on the tires. They questioned the defendant. He stated he had just gotten his taxes back and was celebrating and had 2 large alcoholic beverages.
they asked him where he was coming from. He kept saying Roswell, which is where he was currently, and couldn't really give a clear answer, did seem to be disoriented. He then refused FST and implied consent. We did pull the defendant's driver's history. The only thing we're showing is a super speeder conviction from May of 2018. We are requesting a $3,000 surety bond on the DUI.
Thank you. Ms. Bonstein?
Thank you, Judge. Mr. Osorio Garcia is 37 years old. He has lived in Georgia for 4 years. Before that, he moved to New Jersey in 1993, moved to Georgia to be closer to his family. His parents live here. He's married and has a 12-year-old son. He does have a high school education, and he was in the Army from 2007 to 2016. He did one tour of Iraq while he was in the Army, and he was honorably discharged. And now he serves as a service technician, fixes high-end appliances, and has done that for 2 years. As for this case, it's my understanding that his tire blew out and he pulled over to fix it and thought that law enforcement was going to help him fix his tire situation when he was on the side of the road after they pulled up behind him. In Odyssey, when I looked, it showed a $1,000 bond. Unfortunately, his phone numbers are in his phone. He doesn't have any memorized. He's never been arrested before, so he didn't realize he would need to. And he is not able to contact anyone. So we are asking that the court grant a signature bond for him in this case, so that he would be able to bond out. If the court's not willing to do that, we would ask that the $1,000 bond in Odyssey, that's in Odyssey, remain in place.
So he has a wife and a 12-year-old, and he's been in jail for 3 days, and no one's tried to figure out where he is, I wonder?
His wife is currently in Brazil. He has her number, but since she's out of the country, he can't contact her. His parents are here, but he doesn't have a way to get a hold of them. And right, the 12-year-old, yeah.
All right. It's going to be a $5,000 signature bond through the jail, no drugs, alcohol, or weapons while out on bond. Good luck to you, sir.
Your Honor.
Yes, Ms. Gant.
I do apologize for interrupting. I did hear from Ms. Miller. She is the complaining witness for position 1, Dwayne Anderson.
Okay.
She informs me that she is unable to join the Zoom call because she's unfamiliar with the technology. She states that she does want to continue having contact with Mr. Anderson. So I would ask for a modification in the conditions regarding the stay away and the no further contact orders, and ask in lieu of the no further contact, no violent contact.
All right, this is position number
Your Honor,
1.
the state would object to the modification given the facts and circumstances surrounding this incident.
Okay, my notes indicate that there's not any previous incidents of any type of violence in Mr. Anderson's background. We have heard from Ms. Milner, who has stated that she does want contact. This incident occurred on April 7th of this year. It's currently the 11th, so there's been a cooling off period. As such, there'll be no further violent contact with Ms. Milner in this matter.
Thank you, Your Honor.
And Ms. Lewis, if you could make that adjustment for me. All right, so who do we have next? Thank you, Ms. Gant.
Position number 2, please.
All right. Good afternoon, Mr. Barnett. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002156E with simple battery family violence. Is there a history, Mr. Howard?
It's his 4th arrest. Last was 2019, suspended license. conviction. 2014 theft by receiving dismissed. 2011 misdemeanor obstruction, misdemeanor possession of marijuana. They were dismissed.
All right, Ms. Duncan.
Yes, Your Honor. In this case, on August 3rd, 2021, officers responded to the location of 2285 Metropolitan Parkway Southwest, which is the City Central Apartments, number 517, to a dispute call. They were encountered by the victim in this case, Miss Yakita Barnett, who stated to the officers that she was assaulted by her children's father, the defendant in this case. She stated to officers that she allowed him to come in at the time because their child needed some supplies. She said, however, when he walked into the apartment, she was holding their daughter, and for no reason, he pushed her. And she stated to officers that when he pushed her, she almost fell while holding their daughter, who was 4 months, but she caught herself. And she stated to the defendant at that time that he didn't have to push her while she was holding their baby. And then, Your Honor, she said that after she said that to the defendant, he then presented a handgun and pointed it at her. She stated that after he pointed the gun at her, he left the location. She stated that after the incident, she called his mother and she got no response from her. And she wanted to report the incident. Given the facts and circumstances surrounding this case, Your Honor, we are requesting a $5,000 total surety bond, a no further contact with the victim in this case, third-party child contact, a stay away from the incident location, no alcohol, drugs, or weapons, and 1-day anger awareness.
Thank you, Ms. Duncan. Ms. Gant.
Thank you, Your Honor. Mr. Trayson Barnett is 31 years old. He has been in the Atlanta, Georgia area his entire life. He has been married to Miss Yaketa Barnett for 7 years. They share a child together. We are opposed to the stay away at 2285 Metropolitan Parkway. I did have the occasion to speak to Ms. Barnett, and she is on the Zoom call. She states that she wants to have him home. She wants contact. Mr. Barnett completed high school. He works for DoorDash full time. He denies the allegations, Your Honor. And given my history, my client's lack of history for violence, I am requesting a signature bond on his behalf as he has recommended. We are at this time opposed to the no contact and stay away orders, and would ask that the court grant a no violent contact order if Ms. Barnett's testimony pans out in support of these requests. Thank you, Your Honor.
Thank you, Ms. Gant. Ms. Barnett, I see you there. If you would like to address the court, I'll need for you to raise your right hand for me. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. What would you like to tell the court?
About the day of what happened?
Whatever you'd like to tell the court, ma'am.
I mean, since that day, we've been back around each other. We've been fine. I mean, I can say, we talk, but we're not together. We're separated. We're still married, but we're not physically together. I don't talk to him every day. He don't see his child every day. But I want him to be a part of his child's life, and I want him to be around her. And if she's a baby, she looks for her dad every day. She loves her dad. That's all she says, Dad. So I wouldn't want him to be away from her because she's looking for him right now. So, he is a good dad. I just want him to get help with his anger and stuff like that.
Okay, this happened back on in August of last year. Have you all been around each other since then?
Yeah, we've been around each other. He's been around the baby and stuff. I try to let him get her, but he don't ask to get her like that. But I try to, give him the opportunity, to be a part of her. A part of her life.
Are you afraid of him?
No, I'm not afraid of him.
All right. And you want to have contact with him?
Yeah, I would like to have contact with him. My phone is always open, but we don't get that many phone calls from him.
Okay. Thank you, Ms. Barnett. Ms. Gant, Ms. Duncan, anything further?
Nothing further, Your Honor.
Yes, I'd like to reiterate the nature of the allegations in this case, Your Honor, that's all.
All right. It's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Ms. Barnett, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Barnett, Ms. Barnett also.
Thank you, Your Honor. Your Honor,
Okay. Ms. Gant,
Mr. Coleman informed me that he's done with the interpreter. And
You
I
need-
do have a case.
okay, who do we have in courtroom 3, please?
This is Mr. Gallegos.
Is this your case, Ms. Gant?
Yes, Your Honor.
Okay, so let's put Ms. Gant and the interpreter in courtroom 3 into a breakout room, please.
And I'm back with you, Judge. You just have to tell me how well I'm coming through or not.
Okay, you're coming through, Mr. Lewis. Thank you. And is this Mr. Bachman?
Yes, can we go back to position number
Okay.
2, Judge?
So we're back with Mr. Bachman. I've heard from the state in this matter. Mr. Lewis?
Yes, Judge. Your Honor, we have a 63-year-old here. And if I remember the facts as being asserted from the warrant by the state, the cross defendant goes into a drawer of his and takes rent money out and then hits him with a glass in the head. And then he is alleged to have struck the cross defendant in the head. So that answered, I believe, your question that you asked earlier as to who did what first. Judge, there is just the charge of battery here. And I apologize for my screen going out. It's someone, of course, trying to call during my session.
Okay, you're fine, Mr. Lewis. Anything further?
And I would just object as the state to the categorization of the primary aggressor. That was just the order of the facts alleged. It does not indicate who was the primary aggressor on the official documentation.
Are you with me, Mr. Lewis? We're going to finish up with Mr. Bachman. I don't want him coming back. Okay, so Mr. Lewis. All right, I'm sorry, courtroom 2. Can we go to someone else, please?
Can we go to position number 16, please, Mr. Lewis?
All right, is this your case, Mr. Coleman?
Yes, it is.
Thank you. Good afternoon, Mr. Lewis. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002130C with criminal trespass and obstruction of a law enforcement officer. Is there a history?
7 total. You heard me?
Yes, I heard you.
Our last arrest was April 1st for shoplifting. That was by South Fulton Police. 2021, trespass, shoplifting. November 2021, public indecency, it was dismissed. 2020, probation violation, underlying charge of stalking.
Excuse me, I'm sorry.
Yes.
The Zoom froze on us again. I'm sorry, Judge.
Okay, no, that's no problem. Thanks for letting us know. We were going through the history. So far, 2 shopliftings. What else, Mr. Howard?
2020 stalking conviction. 2006 robbery, ag assault conviction. That's it.
What year was that robbery, ag assault?
06.
Okay.
That's all.
Okay, Ms. Webb?
Yes, Your Honor. This particular incident took place on April the 8th, 2022, when the Georgia State Police Department responded to a trespass call at 175 Piedmont Avenue, Atlanta, which is the Georgia State parking deck letter J on the Georgia State campus. The defendant was found to be in that parking garage, Your Honor. In this particular case, the defendant was actually issued a previous stay away notice on December the 21st of 2021 and December the 12th, 2021, when the defendant was asked to provide his date of birth and his name to the officer. He refused, and the officer, of course, cited him with obstruction and it's obstruction and trespass, Your Honor. The bond is currently set at $1,000 per count with a stay away from the Georgia State campus and no alcohol, drugs, or weapons. We're asking the court to honor the preset bond. As you've heard from pretrial, the defendant has those previous probation violations out of Coweta County from 2021, as well as the ag assault and robbery convictions from Fulton in 2006. But he also has an open trespass case from Atlanta from 2021 as well, Your Honor. Nothing further.
Mr. Coleman?
Your Honor, I would be requesting a signature bond from Mr. Lewis, or in lieu of that, a low bond. He does have his GED, however, he is not working, therefore he has no money at all to post for bond. Remind the court that these are just allegations against Mr. Lewis at this time. Again, we be requesting a signature bond.
All right, it's going to be a $250 good bond on each charge, making for a total of a $500 good bond. Stay away from 175 Piedmont Avenue. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
You're welcome. Good luck to you, Mr. Lewis. Mr. Lewis, are you back with us?
Are you speaking to Craig Lewis, Judge?
I'm speaking to Craig Lewis. Yes, Mr. Lewis.
Okay, I'm so
Right.
sorry. I'm so afraid to try again, Judge.
No, we're going to get through, Mr. Balkman. Did you have anything else you needed to say before
Yes.
Okay, go ahead.
I have no idea what you heard and did not hear, Judge. So let me just start with his age. He's 63 years of age. He's a lifelong resident in the state of...
Can we bring Mr. Balkman back up to the seat, please? Courtroom 2.
Judge, if you can give me one moment. He needs to go to the restroom, so can you just please give me one moment?
Okay.
If it helps the court, or I believe who is a female. I don't know if she's in that same location. I think she is, though.
Say it again, Mr. Lewis. I'm sorry, I didn't hear you.
Miss Ponder?
Yes.
She's there. He's in the restroom, but she's there if you want to do her.
Everybody just be patient with me, okay? One moment. I'm the only person working in the courtroom right now.
Oh, I understand, Sergeant.
Thank you.
Okay, so we've got Mr. Balkman back. Go ahead, Mr. Lewis.
All right. He's 63 years of age, Judge. He is a lifelong resident of the state of Georgia. I don't recall having heard any matters of violence from pretrial services when going through his record. I did hear that he was a convicted felon. I believe I heard the year 1990 for a drug offense. He has at least one failure to appear in his life, Judge. So he doesn't have the 2 or more requisite during the last 5 years. Not having heard anything about violence, Judge, I believe he is a candidate for a signature bond. His only failure to appear that I am aware of came as a result of an inability to get access to the court during our pandemic. I would ask the court at this particular point to give a signature bond. If I heard Madam Solicitor General's statement, this offense occurred at his residence following the cross-defendant having taken his rent money and then hit him in the head with a glass. So not submitting to the fact that he did anything, Judge, but we absolutely, if we can accept the prosecutor's recitation of events as being actually factual, He's doing it in response to both a theft and being struck. So in that instance, I would ask for the signature bond. Judge, one final issue. During my course of looking through to find out if I had any conflicts, I also noticed that the behavior described by my client, Mr. Bachman, is unlike, meaning it is absolutely similar to other history from 2014 to 19 in Fulton County. Thank you.
Anything further, Ms. Duncan?
We just like to add that this defendant does have a violent conviction for my apologies. My computer is freezing.
Oh, mine's done that a couple of times.
1 second, my apologies. I don't know where it went. My apologies, it's not a violent conviction. It's an open case, felony case. 21 CP 204010.
All right, it's going to be a $5,000 signature bond through the jail. No drugs, alcohol, weapons while out on bond.
Thank you, Judge.
No further contact with Stacy Lofton. All right, good luck to you, Mr. Bachman.
Judge, I'm sorry. Can you give me the bond amount for position number 16, please?
I can. Hold on one moment. It's a $250 good bond per charge, which makes it a $5,000 good bond total.
Thank you. And can we go to number 28, please?
500. Yes. 28.
Yes.
Okay, so this is Janetta Ponder, and that's with Mr. Jamal Ponder's case. Good afternoon, Ms. Ponder. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You've been charged in case 22 CR 002149Y with willful obstruction of a law enforcement officer. Ms. Falk, I've heard the information that you relayed for Mr. Jamal Ponder. Is there anything further that you want to make note of?
Just in reference to the history, Your Honor, she has a 2006 conviction for possession of MDMA, a 2012 simple battery conviction, a 2017 DUI conviction, and she's actually currently being held in custody not only on this case, but the 2017 DUI case. It's unclear whether it's a rearrest due to a probation violation or due to a failure to appear for some sort of court hearing, but she is showing being held on those charges currently, as well as with this case. So we are recommending, the current bond is currently $3,000 surety bond. We're recommending a reduction to $1,500, no alcohol, drugs, or weapons.
I've got that's an FTA case that's scheduled for next Tuesday.
Okay. And I know she has, I believe she currently has no bond on that case.
Okay.
Because it hasn't been addressed by the court yet. So we are asking for a $1,500 surety.
All right. And who is
8,000 total bond.
Okay. Mr. Lewis?
Judge, did we get a factual recitation from pretrial on this young lady?
Anything to add,
No.
Mr. Howard?
Okay. All right. Thank you, Judge. So you asked earlier about the anything involving the tow truck driver. So I'm looking at the warrant. The warrant actually says that her crime is pulling away from the police officer when they are trying to arrest her. And the officer goes further to say no violence was done to this officer. So that is the thing in the warrant that we have that she has actually done or being accused of doing. She is 35 years of age, Judge. She is the mother of 2. She does have a failure to appear, and since the court has asked questions about that failure to appear. That failure to appear, Judge, is caused by her having suffered a miscarriage on her third child, who is not with us today. She has 2 children in this area in addition to her lifelong residence. She has 2 siblings in this area. She formerly worked in the automotive industry, but took time off from working in the automotive industry to care for her uncle, who also has now passed away. She has an interview scheduled with Amico 2 days from now to re-enter the workforce now that she's not having to suffer any of those disabilities that we just talked about. She is a person who has completed the 11th grade, Judge, but has not acquired yet her general education diploma. I would ask the court at this particular point, given the charge that we have, and not having heard any other charges similar to it, to issue a signature bond to her as well on this charge. And I would also ask the court if it is giving bonds on the other matter where she has the failure to appear, to reinstitute her prior bond on that matter. And if there is something different that comes out later on through a factual recitation, then of course the receiving court can pick that matter up and deal with it then. Thank you.
All right, I'm only dealing with the with this willful obstruction today. I don't have any information on that FTA, so I'm not dealing.
Your Honor, and just to point out to the court, I hate to interrupt.
No,
the warrant not only states that she pulled away from the officer, but it also states that she kicked multiple officers. I'm sure that was just an oversight on Mr. Lewis's part, not an attempt to misrepresent to the court.
Oh no, Judge, it wasn't an oversight. I kept on reading down further on it where Madam Prosecutor is reading from, and the next statement says, no physical violence was done. So I saw it, but I couldn't take both positions. There was either contact or there was no contact. Okay,
well, you'll all be able to figure that out at a later date. For today, it's going to be $1,000. I'm going to do the same thing that I did with Mr. Ponder. $1,000 good bond, no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
All right.
Thank you, Judge.
Good luck. You're welcome, Mr. Lewis. Do you have any more cases with me?
I'm sorry?
Do you have any more cases with me this afternoon?
I have one, Judge, but I understand that person is a medical reset. Do you have a Meadows? Have you addressed that already?
Yes, he's gonna be a medical reset.
Medical reset, position 21. Michael Meadows. He's position 20 and 21. So we'll reset him for tomorrow.
Okay, Judge, when was his date of arrest?
I've got 4/9.
Judge, I need a breakout session with you, Madam Prosecutor, and the jail.
Okay. Ms. Falk.
I'm ready to do a breakout.
Okay, Ms. Falk.
And Miss Webb also.
Ms. Webb. If you could put us into a breakout room, I guess well, Mr. Meadows isn't here, so.
No, Judge, just the jail. It's good.
So you want me to
We don't need the jail if Mr. Meadows is not here, do we?
Well, no, we don't, Judge. That's just where I received my information from.
Oh,
Miss Ashley? I just trying to confirm because I don't see anyone, if it just froze.
No, you're okay. Judge Morrow went into a breakout room.
Oh, I see. Okay, thank you. I just saw a message. My apologies.
Excuse me, ma'am, but you can't be driving your car while you're on the Zoom meeting. You're gonna need to pull over to the side of the road.
I'm coming, baby, I'm coming. Come show me your work.
Okay, let's see, courtroom 2. We have had a discussion on position 20 and position 21. So just so that you know, courtroom 2 for position 20 on the criminal trespass and damage to property is going to be $1,000 good bond on each count, making it for a $2,000 good bond with a mental health evaluation and other conditions that will be in the bond. And on position 21, battery family violence, it will be a $2,500 good bond also, with a mental health evaluation and treatment if necessary, and with a stay away and no further contact and no drugs, alcohol, weapons stipulations.
Thank
All
you.
right. Who do we have now in courtroom 2?
Judge, I'm sorry. I have position number. I'm sorry, I have position number 4, Mr. Benjamin.
Okay. Good afternoon, Mr. Benjamin. I'm Judge Eric Morrow. This is a state court expedited accusation calendar. You have been charged in case 22 CR 0021638H with driving without a valid license, obscured or missing license plate, battery family violence, driving with a license suspended or revoked, and expired tag or unregistered vehicle. Is there a history, Mr. Howard?
2019 forgery, 3rd degree. That's it.
Ms. Duncan?
Yes, Your Honor. In this case, the defendants stated to officers, were presented a license to officers that expired on March 18th, 2022. The vehicle that the defendant was driving in this case had a thick black tag border that obscured the officer's view of the tag. And when asked about what's wrong with the tag, the defendant also admitted that it was expired. As far as the battery family violence, Your Honor, in this instance, there was a witness who saw a man coming from behind the motel, back of the motel at the incident location, which was around 1375 Virginia Avenue. The witness observed a woman calling for help. And then there was another unidentified person who was attempting to intervene in the situation with the woman calling for help. And then once approaching the woman who was being put into a vehicle, the other bystander who was attempting to help ran away from the location, saying he has a gun. So they left and continued to not help. This witness continued to observe these, the victim and the defendant leave the parking lot of 1375 Virginia Avenue. I believe it was Louisiana Bistro. If my apologies if that is incorrect. Upon leaving, officers followed that vehicle, and eventually, when they were able to bring that vehicle to a stop, Your Honor, they made contact with the victim and the defendant in that case, and the defendant displayed blood on his inner lip and along the sleeve of his shirt. The victim displayed a laceration on her face and some bruising. When asked where she got the bruising from initially, she stated that she did not want to talk about what happened. And the defendant, my apologies, stated that someone was trying to steal their car, and that's where he got the defensive wounds. When asked further to the victim how she got her wounds by our victim advocate, she stated that someone was trying to steal the car, and she fell, and that's how she received her injuries. However, Your Honor, the state has some concern given these facts, and we will request, given the history a split bond of 1,500 signature for the driving charges, that is 500 apiece, and a $3,000 surety bond on the battery family violence for a total split bond of 4,500. No further contact with the victim, no alcohol, drugs, and weapons. While our victim advocate did make contact with the victim, and she stated that they are in a relationship and they live together, that she does not fear the defendant, given the circumstances surrounding the fact that this incident was witnessed by another individual, given facts that may be contrary to the explanation given. We are concerned about the safety of this victim, given the cycles of domestic violence that may occur here. In addition, I'm not sure if pretrial stated it, but it appears that the defendant has a forgery open out of Gwinnett from 2019 as well. So given those facts and circumstances, Your Honor, we request a bond as stated, the $4,500 split bond.
Would you like to give me the victim's name?
Yes, my apologies. One
The
moment.
alleged victim, excuse me.
My apologies, Your Honor. I'm having technical difficulties.
While we do that, Ms. Gant.
Thank you, Your Honor. Mr. Carl Benjamin is 26 years old. He is originally from Guyana, but he has been in the Atlanta area for a very long time. He does have family here, but he does not have any children. Your Honor, we are opposed to, well, the state did not ask for a stay away, but we are opposed to a stay away as this couple, Mr. Benjamin informs me that he lives with the complaining witness, Jada Wise. Your Honor, Mr. Benjamin completed high school. He also has college credits at the Professional Arts Academy. He is currently employed at Amazon and SKC full-time. Your Honor, he denies the allegations and stands by the version that he provided, given specifically that his car, he called and reported that his car and phone were being stolen and that injuries to Ms. Wise were ensued from that incident with the car theft. I am again asking for a signature bond for Mr. Benjamin. He is recommended. Again, he denies these allegations, and my client does not have any prior history for violence and technically doesn't have any history whatsoever, because an open case is just that, an open case, and he's presumed innocent in that case as well as this one. I did have the occasion to speak to Ms. Y. She states that she wants contact, and I don't see her on the line. She did not indicate that she would be here today. So I would ask instead that the court order a no violent contact order and that there not be any stay away conditions, and we do not need any third party transfer orders. Thank you, Your Honor.
I'm here.
Okay, Ms. Wise, if you'd like to have something to say, I'll need for you to raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, what would you like to tell the court?
While we were arguing, someone attempted to steal our car, and that's how I got my bruises. And yeah.
All right, you're not afraid of Mr. Benjamin?
No, sir.
This had not happened before?
No, sir.
All right, anything further, Ms. Duncan? Thank you, Ms. Wise.
I just wanted to add that the defense is correct. The name that I had was somehow showing up wrong. It is in fact Ms. Wise.
All right, so for each of the driving charges, it's going to be a $500 signature bond through pretrial. For the battery charge, it's going to be a $2,000 signature bond through pretrial. Makes a total of $4,000 signature bond through pretrial. No further violent contact with Jada Wise. No drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Benjamin.
Judge, can we go to position number add-on 1, please, Mr. Butler?
Okay. Good afternoon, Mr. Butler. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002176F with criminal trespass. Is there a history, Mr. Howard?
16 total. Last was October 2021, probation violation. Ag assault and battery on a peace officer was the underlying charge. October 2021, obstruction, simple assault on martyr. January 2021, FTA. Disorderly conduct, simple battery. 2019, 2018, probation violations. Simple battery, 2018, DeKalb County. 2017, trespass conviction. It was amended from a theft by taking. The ag assault was from 2016 out of Gwinnett. Had a 2015 armed robbery, ag assault, possession of a knife or a firearm during a commission. He was found not guilty in that one. Sell a cocaine conviction, 08, that's it.
Okay, Ms. Duncan?
Yes, Your Honor. The events alleged in this instance occurred on April 9th, 2022. It's criminal trespass. The incident location is 1325 Donald Lee Hollowell Parkway. Officers were dispatched to this location and they met with a Mr. Channing Henderson, who stated that the defendant in this case was still on his property after already being criminally trespassed the day before. Officers Officers noted that they had been dispatched to the same location 2 weeks prior on an attempt to get the defendant help in finding a place to stay, but he declined. He was approached and he became very aggressive toward officers and other units at the time and stated that he was not going to leave. This location is an abandoned warehouse. However, it is owned by Channing Henderson, and he was notified that he needed to leave. And the criminal trespass case number is 2209807799. And that's from when officers told him to leave the location and he would be arrested if he did not leave that location. Given the facts and circumstances surrounding this incident, the state is requesting $1,000 surety bond, a stay away from the incident location at 1325 Donald Lee Hollowell Parkway, no alcohol, drugs, and weapons.
Ms. Gant?
Thank you, Your Honor. Mr. Eric Butler is 35 years old. He has been in the Atlanta area his entire life. He does have a father in the area. At this time, Mr. Butler is residentially challenged, and we are working with our social worker to connect him to appropriate housing resources. We are unopposed to the stay away at 1325 Donald Lee Hollowell Parkway. Mr. Butler informs me that he completed 8th grade. He basically has been disabled his entire life. He also suffered from a gunshot wound. He has an appointment on Wednesday at the Social Security Administration. He's wanting to be released so that he can make that appointment. He does not have the means to pay any bond at this time. And while I acknowledge my client's history, this is not a crime of violence. And I would ask that Your Honor take that into consideration and grant a signature bond. If Your Honor is not inclined to do so, then the lowest bond possible. Thank you.
All right, $1,000 signature bond through the jail, social worker visit to help with any housing issues that he might have. Stay away from the incident location of 1325 Donald Lee Hollowell Parkway. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Butler. I'm being told that the interpreter has court in another county. Can we take the interpreter cases now, please?
Thank you, Your Honor.
Yes, sir. Position number 10.
And Madam Interpreter, if you can raise your right hand for me. Do you swear affirm that you will translate to the best of your ability from Spanish to English and English to Spanish
I do.
Okay, thank you, ma'am. Good afternoon, Mr. Gallegos, Olivia, Vera. I am Judge Eric Mora, and this is the State Court Expedited Accusation Calendar.
Muy bien, señor Gallegos Olivera, yo soy el juez Eric Morrow, que está presente en las audiencias en cuanto a las acusaciones presentadas por el Estado.
You have been charged in case 22 CR 002170B
Usted ha sido imputado en el caso 21 CR 002170B.
with failure to have license on person,
Número 1, la primera acusación es falta de mantener una licencia válida en su persona,
following too closely,
seguir muy de cerca un vehículo,
reckless driving,
manejar de manera temerariamente,
aggressive driving,
manejar de manera agresiva
racing,
y andar
and exhaust system violation.
También había un quebranto del sistema de exhaust del carro y
Is there
andar
history?
en carrera.
Is there a history, Mr. Howard?
A ver si hay algún tipo de historial en este caso o antecedentes.
This is fourth arrest.
La cuarta acusación y arresto del señor Gallegos.
Last was October 2021 for stalking.
La última fue el 20 de octubre de 2021 por andar de acechanza y merodeo.
That's open in state court, case number 21 CR 005569B.
Este es un caso abierto en el Tribunal del Estado 21 CR 005569B.
2012 driving without a valid license conviction and 2010 driving without valid license arrest.
Dos acusaciones. En el 2012 de conducir sin una licencia del Estado de Georgia y otro arresto por también conducir sin licencia en el 2010.
That's it.
Eso es todo.
Ms. Duncan?
Yes, Your Honor. For each of the charges, there is a total set bond of $3,765.
Muy bien, señoría. En ese caso, por todas las acusaciones, el monto global de la multa es de $3,765.
The set bonds exclude the aggressive driving charge.
El depósito de la fianza no incluye la acusación de conducir de una manera agresiva.
The state is requesting a $1,000 surety bond for the failure to have a license on person.
El Estado está pidiendo que se puede entonces conceder un depósito de fianza bajo aseguranza por no tener una licencia del Estado en su persona.
That is the set bond.
Es una fianza ya asegurada.
The reckless driving charge has a $1,000 surety set bond. We ask that remain.
También queremos que permanezca la multa de $1,000, que es un depósito bajo aseguranza también por conducir temerariamente.
The following too closely charge has a $265 surety bond preset.
También el seguir muy de cerca también tiene un depósito de fianza ya asegurado de $265. Y la petición es que eso siga igual.
The racing charge has a $500 preset surety bond.
El andar en carreras también tiene un depósito de fianza bajo aseguranza de $500.
And the exhaust system violation has a $1,000 surety bond preset.
También existe otro depósito de fianza the interpreter needed a clarification on the amount. I'm sorry.
For the exhaust system violation, 1,000 surety.
También por llevar en el vehículo a usted parece que es un depósito de fianza también de $1,000.
The state is requesting a $235 total surety for the aggressive driving charge.
También el Estado solicita el depósito de fianza en $235 por el conducir de una manera agresiva.
This would bring the total bond in the case to a $4,000 total surety bond.
Eso llevaría a una suma total de $4,000, un depósito de fianza bajo aseguranza en el caso por completo.
The incidents alleged in this case, Your Honor, occurred on April 9th, 2022 on Holcomb Bridge Road.
El 29 de abril de 2022 fue donde se dio el incidente en el puente de Holcomb Bridge.
Detective Miller was traveling west on Holcomb Bridge Road and came to a stop at a traffic signal when he
Parece que
observed a black vehicle.
El policía llegó a una parada del tránsito en la West del Holcomb Bridge cuando observó el vehículo.
Upon observing the black vehicle, it caught his attention because it had an excessively loud exhaust and was rapidly accelerating.
Parece que al ver el vehículo, lo que le pudo notar en el vehículo es que estaba haciendo un sonido bastante fuerte del vehículo y por esa razón lo quiso detener.
The officer continued in the direction of the vehicle.
El oficial continuó a la dirección del vehículo.
And upon observing the vehicle, the black vehicle began to change lanes without using turn signal with multiple cars around.
Por eso en ese vehículo empezó a cambiar de vía de línea, aunque había sin número de carros alrededor, y al escuchar este ruido que venía también al escape.
The vehicle made a right on Old Holcomb Bridge Road and was following a silver vehicle.
Así que el vehículo tomó una derecha en la Holcomb Bridge Road y está siguiendo otro vehículo de plata.
The black vehicle driven by the defendant was following so closely, according to the officer.
Él dijo que el imputado siga muy de cerca el otro vehículo, de acuerdo a las palabras del policía.
That if that vehicle would brake, the defendant would hit the bumper.
Decía que ese vehículo hubiese frenado, entonces el imputado hubiese pegado al paracoche.
The officers observed that black vehicle driven by the defendant began to race another vehicle.
También el oficial notó que el imputado que andaba en el vehículo negro empezó a seguirle a otro vehículo.
The black vehicle driven by the defendant was attempting to outgain and outdistance the vehicle it was racing.
Parece que el vehículo negro, que es el vehículo que estaba conduciendo el imputado, estaba tratando de pasarle al otro vehículo, la cual le estaba corriendo atrás.
Officers continued to follow the vehicle and dispatched additional officers to help with the stop.
En ese momento el policía le siguió al vehículo y llamaron a otros policías también para que pudieran ayudar.
And when officers were eventually able to box the vehicle in,
cuando ya los agentes del orden público pudieron parar el vehículo y
they identified the driver as the defendant in this case.
Pudieron identificar al conductor como el imputado en este caso.
They observed his eyes were bloodshot and watery.
Lo pudieron enjaular en un área de la vía de tránsito. Se dieron cuenta que tenía los ojos ya un poco inyectados con sangre.
Officers noted that they did, in fact, detect an odor of alcoholic beverage on his breath.
También notaron los oficiales del orden público que pudieron notar un olor fuerte, aliento fuerte de alcohol en su persona. El aliento.
Due to the driving behaviors observed by the officers,
basándose en la conducta que pudieron percibir los oficiales,
the defendant was placed under arrest.
El imputado fue entonces detenido y arrestado.
Given the facts and circumstances surrounding this case,
dándose las circunstancias y los hechos que son alrededor de este caso,
the state requests the bond as preset and requested.
El Estado requiere que ese depósito de fianza sea prefijado y se solicita el depósito de fianza bajo aseguranza.
With the condition additionally of no driving unless validly licensed, insured, and registered.
Con las condiciones de que no puede conducir sin tener licencia válida del Estado, al igual que un vehículo registrado y también confirmar que tiene aseguranza.
No alcohol, drugs, weapons, or firearms.
No puede portar armas, ninguna armas de fuego o otro tipo de armas.
And given the history and facts, a defensive driving course.
Y dando el poro de los hechos y el historial de este caso, que toma un curso de defensa.
Nothing further from the state.
Nada más por parte de la fiscalía.
Thank you, Your Honor. Mr. Gallegos Olvera is 42 years old.
Gracias, señoría. El señor Gallegos tiene 42 años de edad.
He has been in the Atlanta area for 25 years along with his wife and 3 daughters.
Ha vivido en el estado de Atlanta por 25 años con su esposa y sus 3 niños.
His children are ages 23, 19, and 13.
Sus niños tienen 23, 19 y 13 años.
He also has 2 grandchildren.
También tiene 2 nietos.
And he's been married for 16 years.
Y tiene 16 años casado.
He completed elementary school and has been unemployed for the past 2 years.
El último curso que atendió la escuela fue la primaria y ha estado desempleado por los últimos 2 años.
He injured his shoulder during a work-related accident that led to a fracture, and he also has a hernia.
Debido a un accidente en el lugar de trabajo, ha estado sin trabajo, incapacitado, lo cual también dio lugar a una hernia y otras fracturas del cuerpo.
He wants you to know that he only earns $675 a month for workers' compensation.
Él quiso que le dejara saber que solo gana $675 al mes debido a los pagos de compensación al trabajador.
He states that he does not have anything to pay toward bond and that his wife and daughter are doing their best to pay the rent that is due.
Al igual, indicó que no tiene nada para pagar hacia la fianza y que su esposa y su niña están tratando, también sus hijas, de recaudar los fondos para pagar la renta mensual.
He denies the allegations and states that he was traveling at 45 miles per hour.
Él niega los alegatos en este caso y indica que estaba conduciendo a 45 millas por hora en las vías de tránsito.
And while we heard about the state's contention that there was an odor of alcohol, my client has not been charged with any DUIs.
Aunque se confirma por parte de la fiscalía que de sus propias declaraciones y se alega de que él tenía un fuerte olor a alcohol en su persona, no se ha imputado a mi cliente con esos tipos de cargos en este momento.
I would also like to ask the court to take into consideration that there were no accidents arising from these allegations.
Al igual que quiero que el juez tome también en cuenta de que no hubo ningún accidente que se elevó por esos alegatos.
Mr. Gallegos Olvera's last driving offense was about 10 years ago.
La última infracción de tránsito fue hace 10 años por el señor Gallegos.
And given the passage of time and his inability to pay, we are requesting a signature bond on his behalf.
Y debido a la situación de que no puede pagar por el depósito de la fianza en este momento y que el último cargo de tránsito fue hace 10 años, pedimos un depósito de la fianza bajo palabra de honor.
Supporting this request is that we did not hear about any failures to appear nor any probation violations.
Basándose en los hechos también que tampoco tiene el señor Gallegos ninguna falta de comparecer al tribunal ni ningún quebranto de la libertad condicional en otros casos.
Nothing further, Your Honor.
Nada más, señoría.
If I may, Your Honor.
Si me permite, señoría.
A correction for the record.
Queremos indicar para las actas.
The preset
Correcto.
bond on the exhaust system violation is in fact $150 surety.
Debo indicar que el depósito de la fianza prefijada en cuanto a la violación del sonido el escape es $150.
So the state would in fact be requesting a $3,150 total surety bond.
Entonces, el depósito de fianza bajo seguridad que solicita el Estado es $3,100.
Given the preset charges and the additional $235 for the aggressive driving charge.
dando los depósitos de fianza prefijada y también de conducir de una manera agresiva, que la cual se le va a añadir $230 por esa acusación.
Nothing further.
Nada más.
Okay, these are all gonna be signature bonds through the jail.
Eso va, todo van a ser depósito de fianza bajo aseguranza y firma por parte, por la cárcel.
Failure to have license on person, $250.
Falta de conducir con la licencia válida en su persona, $250.
Following too closely, $250.
Seguir muy de cerca, otra multa de $150.
Reckless driving, $1,000.
Conducir una conducta temeraria, $1,000.
Aggressive driving, $250.
Por conducir de una manera agresiva, $250.
Racing, $1,000.
Andar en carrera, $1,000.
Exhaust system violation, $250.
Quebranto del escape del vehículo, $250.
Makes for a total of a $3,000 signature bond through the jail.
Sería una multa total de $3,000 de depósito de fianza bajo firma en la cárcel.
No drugs, alcohol, weapons while out on bond.
No puede consumir alcohol o estupefacientes o portar un arma mientras esté libre bajo fianza.
And of course, no driving without a valid driver's license.
Y de acuerdo otra vez, no puede conducirse una licencia válida del Estado.
Good luck to you, sir.
Buena suerte, señor.
Position number 19 is next, please.
Good afternoon, Mr. Lopez. I'm Judge Eric Morrow, and this is the State Court Expedited Accusation Calendar.
Buenas tardes, señor López. Yo soy el juez Eric Morrow y esa es la acusación formal por parte del Estado de casos tomado en cuenta, acelerado.
You've been charged in case 22 CR 002131A.
Usted ha sido imputado en el caso 22 CR 002131A.
With driving under the influence of alcohol less safe.
Conducir bajo el efecto de alcohol sin tomar en cuenta la seguridad del público.
Driving on the wrong side of the road.
Manejar en la vía de tránsito equivocada.
Operating without lights as required by law.
Conducir un vehículo sin las luces encendidas como requiere la ley.
And driving without a valid license.
Al igual que conducir sin una licencia válida.
Is there a history, Mr. Howard?
No.
No existe ningún historial en este caso por parte del imputado.
Who's representing for the state?
¿Quién representa al Estado?
Does someone want to represent for the state?
Your Honor, you said position 19 as Lopez?
That's correct.
Okay.
Your Honor, do you remember it was Mr. Coleman?
I'm the public defender. I'm the defense.
Right.
Oh, my apologies. I said public defender.
So it's not Miss Webb, Miss Duncan, Miss Falk.
Estamos buscando al abogado del fiscal. En este caso.
Not me, Your Honor. I'll check. Your Honor, our apologies. I believe there may be some technical difficulties.
And Your Honor, I can address that bond hearing if it will assist.
Thank you, Ms. Park. We appreciate it.
Not a problem. Let's see. Lopez. I just need a moment to pull up Miss Webb's recommendation so that I can see the facts on this case.
Okay.
Let's see. All right, Your Honor, this incident occurred on April 8th of 2022 at 1470 Holcomb Bridge Road.
Señor presidente, se sucedió el 8 de abril 2022 en la 1475 de Holcomb Bridge Road.
Officers conducted a traffic stop on a Jeep Patriot after he observed the vehicle operating without activated headlights in conditions of darkness, traveling in the opposite lane of traffic.
Parecía que los oficiales hicieron una parada de tránsito cuando observaron este Jeep cuando estaba conduciendo sin las luces encendidas y también siguiendo en el carril equivocado.
The defendant did not possess a valid driver's license, and the initial officer believed the defendant was impaired, and so he turned the matter over to a officer who is qualified in doing field sobriety testing.
En este momento el oficial que hizo la parada se dio cuenta que el imputado que fue detenido estaba embriagado en esta parada de tránsito, por eso entonces puso otro policía encargado que podía hacer una prueba de sobriedad en el sitio.
The officer detected the odor of alcohol coming from the defendant's breath.
El oficial sí detectó el aliento de alcohol que venía también de la persona, del imputado.
Defendant's eyes were bloodshot and glassy, and his speech was slurred and slow.
Decían que también el imputado estaba arrastrando sus palabras y de los ojos inyectados con sangre.
When asked where he was coming from, the defendant initially said Mexico.
Cuando se le preguntó de dónde venía, al inicio el imputado dijo de México.
And then correctly stated he was coming from Eagles Crest Village.
Y después se corrigió, dijo que venía de Eagles Crest Village.
The defendant initially admitted to consuming 2 beers.
Al principio, el imputado admitió que había consumido 2 cervezas.
And when the officer had him step out of the vehicle, the defendant appeared unsteady on his feet and was swaying side to side and unable to maintain his balance.
Cuando el oficial pidió que se saliera del vehículo, el oficial se dio cuenta que no se pudo mantener parado y estaba tambaleando de un lugar al otro al salir del vehículo y desmontarse.
Defendant failed the HGN.
El imputado entonces falló la prueba de sobriedad del sitio, conocida como HGN.
And was placed under arrest and read implied consent, which he refused.
Y fue arrestado, pero se negó a lo que se conoce como la reconocimiento de implícito de consentimiento.
The recommendation on this case, Your Honor, is a $4,000 surety bond.
Las recomendaciones en este caso es una multa de $4,000 en depósito de la fianza bajo aseguranza.
The recommendation is $2,500 on the driving under the influence of alcohol less safe.
También de conducir bajo el efecto del alcohol estupefaciente, que es una manera con peligro, de $2,500 por ese depósito de fianza, también de recargo.
And $500 on the remaining charges of driving on the road, wrong side of the road, operating without lights, and driving without a valid license.
También $500 que queda que se va a añadir a este recargo por conducir con las luces encendidas necesarias, seguir en el carril equivocado.
We are asking that the defendant also have no alcohol, drugs, or weapons.
También estamos solicitando que el imputado no pueda cargar una arma o arma de fuego y tampoco consumir alcohol.
And the defendant not be allowed to drive unless he has obtained a license.
Y que el imputado no se le permita manejar, solo se obtiene una licencia válida al Estado.
Nothing further from the state.
Nada más por parte de la Fiscalía.
Thank you, Ms. Falk. Mr. Coleman?
Gracias, licenciada.
Your Honor, I'd be requesting a signature bond from Mr. Lopez.
Lo que solicito es un depósito de la fianza bajo palabra de honor, es decir, firmado por el señor López.
He is 34 years of age.
Tiene 34 años de edad.
He's lived in Fulton County for the last 4 years.
Ha vivido en el condado de Fulton por los últimos 4 años.
He went as far as 9th grade and is currently employed doing construction work.
Trabaja en construcción y ha estado empleado los últimos 4 años también trabajando por su propia cuenta.
He is the father of 4 children, ages 6, 9, 10, and 14.
Es el padre de 4 niños, variando de edad de 6, 8 y 14.
From what I hear, this is his first arrest, therefore he has no criminal history.
De lo que pude entender, es la primera vez que es arrestado y no tiene ningún antecedente penal.
Therefore, we would be requesting a signature bond on his behalf.
Por eso, a su favor, pido que sea un depósito de fianza bajo firma, es decir, bajo sus palabras de honor.
Okay, this is going to be a split bond.
Sería un monto de la fianza dividido.
For the DUI, it's going to be $1,500 good bond.
Por el MBI sería una multa en buena fe de $1,500.
And for the other 3 charges, a $500 each signature bond through the jail.
Y también por los otros las 3 otras acusaciones sería $500 por cada uno de ellos. También el depósito de la fianza directamente por la cárcel, bajo palabra de honor y firma.
No drugs, alcohol, weapons while out on bond.
No puede consumir ningún alcohol, cargar un arma mientras está libre bajo depósito de la fianza.
And of course, no driving without a valid license.
Y al igual no puede conducir sin una licencia válida.
Good luck to you, Mr. Lopez.
Buena suerte a usted, señor López.
Do we have any further need for Madam Interpreter today?
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
Appreciate it.
Thank you, Ms. Hanson.
Thank you so much.
Number 7, and next judge.
Good afternoon, Mr. Cardona. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002166F with battery, family violence, cruelty to children in the 3rd degree, hindering a person making an emergency telephone call, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
Second arrest, last was 2020 battery DV. It was Nod Prost. He's a resident of the Bronx.
All right, Ms. Duncan.
Yes, Your Honor. In this case, the incidents occurred on September 26, 2021. Officers responded to the location of 8106 Fairview Bluff in reference to a 911 hang-up call. The call notes initially stated that someone from this address and phone number called 911 twice, but the line got disconnected both times. When officers were en route to the address, the call notes were updated that the incident would be a domestic dispute, and a woman named Jessica Cruz called saying that her husband put his hands on her. Jessica Cruz is the victim in this case. The defendant is her husband. Upon officers' arrival at the location, they observed and commented that the victim in this case, Ms. Cruz, her demeanor was anxious and upset. She was in tears, and she told officers that her husband, the defendant in this case, put his hands on her in front of their children. The officers noted that the Ms. Cruz had apparent injuries, including a laceration on her jawline on the right side of her face, and on the right side of her face was swollen. They also noticed that her left hand and around her thumb was swollen. She also had a minor cut on her right ankle. Officers asked Ms. Cruz what happened, and she told officers that the defendant came home drunk and was smelling like marijuana and was talking about hanging out with people on a boat. Cruz told officers at that time that she had set him up with a job opportunity that day and asked who he had been hanging out with. Ms. Cruz told officers that the defendant became defensive and got angry with her for asking those questions. Ms. Cruz explained to officers that the defendant shoved her and told her to stop interrogating him. Ms. Cruz told officers additionally that once he was in their bedroom, he broke a plate by throwing it down. She told officers that he continued to shove her and started swinging at her. So she grabbed her phone and tried to call 911. She told officers that the defendant grabbed her by the arms and began swinging her around, trying to take the phone from her. Cruz further stated to officers that by the time they were back in the living room, dining room area, they were in front of their two children, at the time 12 and 9 years old. Cruz told officers that she is not sure what happened next. She attempted to shove the defendant off of her while he was swinging his fists and arms at her. She tried to call 911 again, but the defendant in this case grabbed the phone from her and threw her phone out the back door towards the creek in the backyard. She stated that after that, the defendant walked off down the road and she didn't see where he went. Officers took photographs, and this is the basis for the incidents alleged. The state is requesting for this incident, Your Honor, a total of, my apologies, my computer is freezing. 1 second. My apologies, technical difficulties. We're requesting a $5,000 total surety, Your Honor. That's $3,500 for the battery family violence. And let me make sure my math is correct. And for the additional charges of cruelty to children, we're asking for $500 total surety apiece, Your Honor, and with additional conditions of no further contact with the victim in this case, third-party child contact, a stay away from the incident location, 1-day anger awareness, no alcohol, drugs, or weapons. Nothing further.
Ms. Gant.
Thank you, Your Honor. Mr. Victor Cardona is 33 years old. He currently resides in the Bronx, New York area, but he has ties in the Atlanta area, including his wife and 2 children that he shares with her. The children are ages 13 and 10. Your Honor, Mr. Cardona informs me that he is in the process of wrapping things up in New York and that he plans to relocate to the Atlanta area. He states that he is here now visiting his kids and he was unaware of the warrant. Of course, as we heard, this incident happened back in September 26, 2021, and they have been having contact with each other without incident. Of course, he denies the allegations, Your Honor. Mr. Cardona completed 10th grade. He is now unemployed. Prior to that, he was operating a high-low equipment in New York. We are opposed to the stay away at 8106 Fairview Bluff, Fairview Bluff in Alpharetta, as that is the home where children are raised. And of course, he wants to continue being involved in his children's lives. We heard about my client's case for battery domestic violence. That was no prostant, Your Honor. We would ask that you view that for exactly what it is, no prior conviction whatsoever. And this couple has been together for over 10 years, and yet that first charge was in 2021, and that was no prostant. Of course, we do not take any allegations of domestic violence lightly, Your Honor. However, in this case, again, my client denies the allegations. I am requesting a signature bond on his behalf, Your Honor. And again, we are opposed to any stay away conditions and would ask that Your Honor order no violent contact. Thank you.
Ms. Cruz, I see you there. If you would like to address the court, I'll need for you to raise your right hand for me. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, ma'am. What would you like to tell the court?
Your Honor, in the time since the incident about 7 months ago, my husband, Victor Cardona, has been to several anger management classes, and he's been very self-aware, more conscious of his actions and reactions. I'm proud of his progress, considering, his upbringing with addict family members. He came here so as not to become a product of his environment, but to start fresh and, teach our children that people can change, not be stuck in those negative circumstances. This of course takes time and mistakes will be made, but we're both learning, and he is a great guy, beloved by me and my children, of course, and he doesn't deserve to be there. And I urge you to, consider keeping a family together and just the opportunity for us to move forward and grow and learn together.
Has he been living with you since this incident, Ms. Cruz?
Yes, yeah.
And he's, you're not afraid of him?
No.
Nothing has happened since this incident?
No.
Anything further, Ms. Cruz?
That's all. Love you.
Anything further, Ms. Gant, Ms. Duncan?
Yes, Your Honor, I would, if I did not say so, Mr. Cardona is recommended for a signature bond through the jail.
There's one more thing, I'm sorry.
Yes, Ms. Cruz.
He never laid hands on the children. That was absolutely false. I never stated that. I never wrote that. He never harmed them.
Okay, thank you. Ms. Duncan?
I just wanted to clarify his place of residence. The public defender, Ms. Gant, stated that he's a resident of New York. Is it the court's understanding that he resides with Ms. Cruz at the incident location, Ms. Gant?
No, that is not our position. He informs me that 8106 Fairview Bluff is the residential home where his wife and children reside. He, at this time, resides in Bronx, New York, and he is in the process of relocating back to Atlanta.
Okay, thank you for that. Given the facts and circumstances surrounding the case, we request that the bond remain as stated, given the concerns for witness intimidation, given the fact that they are married, as well as ties to the community, given that he is currently not residing in the state of Georgia.
All right, so these are all going to be signature bonds through the jail for the battery family violence at $3,500 signature bond through the jail. For each of the other charges, a $500 signature bond through the jail. No further violent contact with Jessica Cruz. No drugs, alcohol, weapons while out on bond. I'm giving you the opportunity to get out, Mr. Cardona, but you're going to have to come back to the court to answer for these charges at a later time. You understand? All right, good luck to you, sir. You also, Ms. Cruz. All right, who do we have next?
Position number 9, Judge, please. You.
Good afternoon, Mr. Ellis. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002168B with criminal trespass. Is there a history, Mr. Howard?
His fourth arrest, 2019 obstruction, felony, disorderly conduct. That case number is 19 SC 172578. He had a reckless driving conviction from 2017. 2010 arrest for CWAC charge. That's it.
Duncan?
My apologies, Your Honor. If I may, back to position 7 for a second. I did not hear a recitation for the hindering 911 charge.
I said 500 for each of the additional charges. So it's 500 for charge 2, 3, and 4.
Okay, thank you. And this is position.
This is position number 9, Mr. Michael Ellis.
Okay. That page. In this case, Your Honor, the defendant remained on Walmart's property in their parking lot at 5200 Wynwood Parkway after being issued a prior criminal trespass warning twice. He was warned not to come back to the property and told that he could be arrested, but he continued to come back to the property. Given the facts and circumstances of this case, the state is requesting that the bond remain as set at $1,000 surety with a stay away from all Walmart and no alcohol, drugs, and weapons.
Ms. Gant?
Thank you, Your Honor. Mr. Michael Ellis is 40 years old. He has been in the Atlanta area his entire life. He states that he does not have any children. We are unopposed to a stay away at just the 5200 Wynwood Parkway. We are opposed to a stay away order for all Walmarts, as we believe that is excessive, and my client is presumed innocent in this matter. There were no allegations of any violence toward any patron. Mr. Ellis is unemployed and has been so for 6 years. He believes that he is disabled but has never been approved for disability, Your Honor. Given the nature of the allegations, I am requesting a signature bond on Mr. Ellis's behalf as he is recommended through the jail. And we are again unopposed to a stay away at just the Walmart at the incident location. Thank you.
All right, a $2,000 signature bond through the jail, stay away from the Wynwood Parkway Walmart, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Ellis.
Thank you. Thank you.
You're welcome.
Position number 11, please. Give me the water, go ahead. Welcome.
Good afternoon, Mr. High. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002171A with simple battery family violence. Is there a history, Mr. Howard?
16 total. 2020 battery family violence proven in the third. He got opened that case 21 CR 003725A. Has an open 2-count simple battery family violence, 20 CR 006162A. 2011 ag assault conviction. 2012 battery family violence conviction. 2013 FTA simple battery. 2013 forgery in the third conviction. 2014 battery DV dead docket. That's some probation violations. 2018, 2 counts of reckless conduct conviction, 1 count cruelty in the third conviction. That's it.
Ms. Webb?
Yes, Your Honor. This particular incident occurred on March the 19th, 2022 at 447 Thackeray Place. That's Thackeray, Thackery Place, Atlanta, Georgia. And the Atlanta Police Department responded to a dispute call, and they were met with Miss Shanta Evans. That's Shanta, SHAWNTA Evans, common spelling, who is the victim's mother. Miss Evans informed the officer that she and her long-term boyfriend, the defendant, who also share a minor child together, were in a domestic dispute after he accused her of a case or act of infidelity earlier in the afternoon. The verbal altercation escalated between Miss Evans and the defendant, and the defendant's Miss Evans' minor child attempted to defuse that argument, and the defendant began attacking her by punching her in the face with a closed fist and began dragging her on the ground. Miss Shanta Evans reported to the officer that she saw the defendant reach into his pocket, and she was unaware of what the object was, but she presumed that it was and she feared that it was a handgun, Your Honor. When the fight ended, the defendant took the minor child that shared between Miss Shanta Evans and he and left the scene. He later sent Miss Shanta Evans a text message saying that he is going to show her. Miss Evans also reported that the defendant is battling alcoholism and that this incident is rooted in him being intoxicated on that evening and at the time, and that when he is under the influence of alcohol, he is often unable to control his anger. The minor did report that she sustained lacerations and bruising from that physical dispute with the defendant, but the responding officer noted that he did not see any visible injuries at that time. Your Honor, the state is requesting a $4,000 surety with a stay away from that 447 Thackeray Place address. No further contact with Ms. Shanta Evans and the minor child TE, no alcohol, drugs, or weapons, and one-day anger awareness, Your Honor. The state is concerned with risk of reoffending and witness intimidation in this case. As we've heard from pretrial, the defendant does have two open cases, one from December 22 for simple battery out of Atlanta family violence, and another case occurring in that same month for simple battery and cruelty to children out of East Point, Your Honor. The defendant also has FTA'd on a previous simple battery family violence case in 2013 in Fulton County. And Your Honor, the defendant does have that conviction for reckless conduct and cruelty to children in 2019. And considering that the parties do live together in one household, the state is concerned with witness intimidation and the history of violence exhibited by the defendant and the defendant's drinking history. We are concerned of witness intimidation. Nothing further.
Ms. Gant?
Thank you, Your Honor. Mr. Jarvis High is 35 years old. He has spent in the Atlanta area his entire life. He has family here, including 3 children, ages 18, 10, and 4. Children are in Georgia, but he informs me that he does not share any children with Ms. Shanta Evans, the complaining witness. Your Honor, we are opposed to any stay away orders at 447 Thackeray Place. This couple lives together, and I did have the occasion to speak with her. She states that she wants to continue having contact with him and her daughter. The minor TH is Miss Shanta Evans's daughter, not Mr. High's daughter, but they are a family and live together as such. Mr. High obtained a GED. He states that he was unaware of this warrant. He turned himself in. It came up while he was trying to do something with his employment, Your Honor. He states that he is employed at Nova Health Services. He is a truck driver. He denies the allegations. And while I acknowledge my client's history, he is presumed innocent in those 2 open cases. And I would just bring to the court's attention that his convictions are, absent the serious charges are over or 10 years ago. And this is despite what's alleged in the warrant, a simple battery family violence allegation. For these reasons, Your Honor, I am requesting a signature bond. If Your Honor is not inclined to grant one, then a bond of no more than $1,000. And again, we are opposed to the stay away order and would ask that Your Honor grant a no further violent contact order. Thank you, Your Honor.
It's going to be a $2,000 good bond, no further violent contact with Shanta Evans, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. High.
Judge, position number 13, next please.
13. Good afternoon, Mr. Jackson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002172G with battery in a public transit vehicle or station. For history, Mr. Howard.
Fifth adult arrest. 2015 criminal damage to property, second degree. It's dismissed. 2010 disorderly conduct. 07 simple battery, not prosecuted. 2005 arrest for battery. He was convicted for simple battery. Misdemeanor possession of marijuana.
All right, Ms. Webb.
Yes, Your Honor. This particular incident took place on January the 26th, 2022 on a rapid rail car, Your Honor, at 2424 Piedmont Road, where the MARTA Police Department responded to a dispute call on a rapid rail car where the defendant allegedly attacked the victim, Mr. Robert Wesley. That's Robert, common spelling, Wesley, Westly, on train car 208 at the Lindbergh station around 1:15 a.m. The facts behind the dispute are still being investigated, Your Honor, but the responding officer was able to review cars 208 footage and saw the defendant strike Mr. Wesley in the face with a closed fist several times, which resulted in lacerations and bleeding to Mr. Wesley's face, Your Honor. In this particular case, the state is requesting a $3,000 surety with no further contact with Mr. Robert Wesley, a stay away from the MARTA at Lindbergh station, and no alcohol, drugs, or weapons. Your Honor, the state is concerned that the defendant is a possible threat to the community. The officer did note that this event seemed absolutely unprovoked. And the state is concerned that this is a random act of violence against an innocent citizen, Your Honor. Nothing further.
Ms. Camp.
Thank you, Your Honor. Mr. Anthony Jackson is 33 years old. He has been in the Atlanta area his entire life. He has family here. We are opposed to the stay away at Lindbergh Station unless there is an active suspension in place. Mr. Jackson informs me that he does not have a car and relies heavily on public transportation. He completed the 12th grade. He is unemployed at this time. He denies the allegations. He states that he does not know Mr. Wesley. He states that the allegations are false and that it has to be a case of false identification, as he did not have any contact with Mr. Wesley whatsoever. I am requesting a signature bond on Mr. Jackson's behalf. I see that he has a simple battery conviction, but it is 2005. We believe that that is too remote for the court to consider, Your Honor. We are unopposed to any no contact, as Mr. Jackson again states that he does not know Robert Wesley. We are opposed to the stay away unless there is an active restriction. And thank you, Your Honor. Nothing further.
All right, $5,000 signature bond through pretrial, 1-day anger awareness class. No further contact with Robert Wesley, and he's to comply with any MARTA suspensions. Good luck to you, Mr. Jackson.
I apologize. Position number 29 is next, please, Judge.
Okay. Good afternoon, Mr. Shinholzer. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002150J with criminal trespass. Is there a history, Mr. Howard?
It's third arrest. Simple battery, 2013 dismissed. 2006 obstruction dismissed.
Ms. Falk?
Yes, Your Honor. This happened on February 6, 2022. Officers responded to 150 Bell Street Southeast, apartment 4103. This stemmed from an incident that happened February 3rd. Officers spoke to Ashley Shinhoster, and that is Ashley, common spelling, and Shinhoster, same last name as the defendant, who stated that the defendant, her ex-husband, had come to visit and become hostile when asked to leave. The defendant stated to Ms. Shinhoster, "You're not about to little boy me, I'll leave when I'm ready," and then kicked her 65-inch television, damaging it and causing it to become inoperable. At the time, Ms. Shinhoster stated she is afraid of the defendant, and they are divorced and no longer live together, and they do share a 4-month-old son. According to Ms. Shinhoster, she did not call the police until the 6th due to COVID quarantine. And the defendant does have a simple battery from 2013 from DeKalb County that was subsequently dismissed. The state is requesting a $2,000 surety bond. Stay away from Ms. Shinhoster and 150 Bell Street Southeast, apartment 4103. No alcohol, drugs, or weapons, and 1-day anger awareness. We have spoken to Ms. Shinhoster, who is changed her statement from what she told police in February. She stated that she is not afraid of the defendant and wants to have contact with him. However, the state's concern is that, and she also further states that she was very upset and emotional that day, and that's why she proceeded with charges. Here's where the state has a difficulty reconciling this. The incident happened on February 3rd. She was in COVID quarantine, and then still by February 6th, felt alarmed enough about this situation to call the police, have them come over, make a full report, and take out a warrant on him. So the state does have some concerns that there were some conditions that may still be present that we need to be aware of and need to be careful of because of the length of time where she did have a cooling off period if this was just her acting or reacting emotionally, and she still went ahead and took out a warrant because she stated at the time, and we believe this to be true at the time, she was afraid of the defendant. So that is the basis for the state's recommendation, and Ms. Shinhoster is here in case the court wishes to hear from her directly as well.
Thank you, Ms. Falk. Ms. Braunstein?
Thank you, Judge. Mr. Shinholster is 35 years old. He is from Atlanta, has lived here his whole life. His whole family's in the area, mom, aunts, cousins, uncles, his 3 children. He, as the state said, is divorced. He graduated high school and has gone through some college. And he informed me that he works at a pawn shop, and he has been doing that type of work since 2016. As both the state and pretrial indicated, he does have prior arrests, but no prior convictions. He and his ex-wife do not live together. My understanding is that this was it was an argument, and certainly I would like the court to hear from Ms. Shinholster if she would like to make a statement. This occurred about 2 months ago, according to the state and the warrant. And Mr. Shinholster did want to inform the court that he turned himself in once he found out about the warrant. So he's certainly not a flight risk with his lack of convictions. And I believe that he was recommended for a signature bond pretrial. So I would ask the court to consider a signature bond for this case and no violent contact with the complaining witness.
Good afternoon, Ms. Shinholster. I see you there. If you would like to address the court, I see that you have your hands full. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth?
Yes, sir, I do.
Okay.
I do.
Good
Good afternoon, Your Honor.
Good afternoon, ma'am.
I do not wish to pursue any charges. I was upset, overwhelmed about financial hardship and dealing with postpartum depression after having our son. As I reflect and be honest, I was an agitator to the verbal misunderstanding between Michael and I. There was nothing physical. Michael is a great working man. He's, of course, completed high school, have some college experience. He's a great father to our son, as well as my oldest son, whose father is not in his life. He has been a great support to me during my postpartum depression, and he loves his family, and we're going to learn to be effective communicators to each other. In conclusion, I request the courts dismiss this case.
Okay, I'm not going to dismiss the case, Ms. Shinholzer, but I appreciate what you've had to tell the court. Are you afraid of Michael?
No, I'm not afraid of Michael.
Have you been around him since the incident date?
I took him to see the baby. Well, I took the baby to see him before he turned himself in on yesterday.
Okay, all right. Thank you, ma'am. It's going to be $1,000 signature bond through pretrial, one-day anger awareness class, and no violent contact with Ashley Sinholzer, no drugs, alcohol, or weapons while out on bond. All right, good luck to all of you.
Thank
All right.
Judge, position number 17, Mr. Little, isn't it?
Is this position 17?
Position 17, Judge, Mr. Little.
Mr. Little. Good afternoon, Mr. Little. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. You've been charged in case 22 CR 002174D with criminal trespass. Is there a history, Mr. Howard?
30 total. 2016 terrorist threats. Simple assault, simple battery, criminal trespass. Entering auto and a parole violation. Possession of tools for commission of a crime, entering auto, those were convictions. Phase 2 appears. It's all one arrest from 2014. Another phase 2 appear 2014, entering auto. Misdemeanor obstruction conviction, 2013. Probation violation, 2013. You want more? That's enough.
No, you're fine. Thank you, Ms. Webb.
Yes, Your Honor, this incident took place on April the 9th at 2021 at 1152 Delaware Avenue Southeast, where the defendant was found by the Atlanta Police Department wandering around the property, which is a residence located at the address, Your Honor. He was found upstairs in that home, and the defendant made entry or allegedly made entry by climbing through a window on the home's front porch. He told the officer that he entered the home because he was attempting to stay warm from the weather that particular day, Your Honor. The state is requesting an increase from the $1,000 surety to a $2,000 surety because this was a residence, Your Honor, with a stay away from the 1152 Delaware Avenue Southeast address and no alcohol, drugs, or weapons, Your Honor. The state is concerned that the defendant is a possible threat to the community. As already stated, this was a residence that the defendant entered into, Your Honor, and we do believe there's a possible risk of reoffending. As you've heard from pretrial, he does have those previous cases for entering auto with the convictions from 2014, and also concerned with that he's a possible flight risk as he does have that previous FTA from Fulton County from August of 2014 as well, Your Honor. Nothing further.
Mr. Coleman.
Your Honor, be requesting a signature bond or in lieu of that, a low bond for Mr. Little. He is a resident of Atlanta, Fulton County, went as far as the 10th grade. He is currently unemployed, therefore he has no money to post for bond. Again, we'd be requesting signature bond or in lieu of that, a low bond for Mr. Little.
All right, I'm gonna leave the bond where it is, $1,000 good bond, stay away from the Delaware Avenue address, no drugs, alcohol, weapons while out on bond.
Thank you,
Not to
Honor.
Mr. Little.
I'm sorry, Judge, what was the bond amount?
1,000, good bond.
Thank you. Next, we have position 23, Mr. Miller.
We've had a change out in courtroom too.
Yeah, it's me, Judge Francois.
Hey, good afternoon.
Good afternoon, Judge.
Is it Metier? Pronounce your last name for me, sir.
This is Mr. Miller.
Position 23.
23? Oh, okay, thank you. Good afternoon, Mr. Miller. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You've been charged in case 22 CR 002160F with fare evasion and criminal trespass. Is there a history, Mr. Howard? Is he back yet? I don't think so. Ms. Webb?
Yes, Your Honor. This particular case occurred on yesterday, actually, where the defendant attempted to skip the fare at the Peachtree MARTA station at 216 Peachtree Street, Atlanta, Georgia. Your Honor, the state is recommending a total $1,500 surety bond. In this case, $1,000 for the trespass, which is preset, as well as the $500 fare evasion surety, Your Honor, with a stay away from that MARTA station located at 216 Peachtree, and no alcohol, drugs, or weapons. The defendant does have 4 active MARTA suspensions. So the state is concerned with the risk of reoffending and that the defendant is a possible flight risk. He has an open case for trespass from MARTA from an earlier case that occurred in February of 2022. And he also has an extensive history out of Kansas, which includes FTAs from Kansas in 2016 and 2018, Your Honor. Nothing further from the state.
Mr. Coleman?
Your Honor, I'd be requesting a signature bond from Mr. Miller. He is 35 years of age, resident of Atlanta, Fulton County. He is a high school graduate, currently unemployed, therefore he has no money to post for bond. These are nonviolent offenses. Again, I'd be requesting a signature bond.
All right. It's going to be a $500 SOB through the jail on each count. And Mr. Miller, you can't go back to MARTA, okay? If you go back there and they pick you up again, then you're not going to get a signature bond, okay? So stay away from MARTA. No drugs, alcohol, weapons while out on bond.
Thank you, Your Honor.
Good luck to you, Mr. Miller.
Officer Norristown, Your Honor. This is position number 30, Mr. Trumbull.
Good afternoon, Mr. Trumbull. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002151Y with battery family violence. Is there a history, Mr. Howard?
Third arrest, suspended license, suspended registration, 2018. 2016 window tint and misdemeanor possession of marijuana.
Ms. Falk?
I'm sorry, were those arrests or convictions?
Arrest.
Okay, thank you.
Your Honor, this incident happened yesterday at 7:30 p.m. So at this point, 24 hours has not elapsed. It occurred at 107 Cimarron Parkway. Officers spoke with Tawana Coleman. That is TYWANNA, Coleman, COLEMAN, who stated that the defendant, who she had been living with, had punched her in the right eye during an argument. Officers were able to observe a welt and a cut to Ms. Coleman's right eyebrow. And the defendant, as pretrial stated, had 2 prior charges, one in 2016 and one in 2018, traffic and possession of marijuana charges. The state has spoken with Ms. Coleman through our victim advocate, and she confirmed that they have been living together for 6 years, have 3 children together. She has also stated the defendant has been verbally and physically violent to her in the past. She stated that he did punch her in the eye and that she is going to the ER today to get it checked out. Although she stated she is not afraid of him, she also then stated she can no longer live in the apartment anymore and under the same roof with him, and that she is relocating. So, and that she is in the process of filing a TPO. So I will say, Your Honor, that although she says she's not afraid of the defendant, all of the actions that she is taking is indicative of somebody who has serious concerns about future behavior. The state's recommendation based on all of those facts is a $3,000 surety bond, no further contact with Ms. Coleman, and a stay away from 107 Cimarron Parkway. We also are requesting that if the defendant is going to retake the residence for any reason, understanding that she's stating she will no longer be living there, that a one-time police escort take the defendant over to that location to ensure she is no longer at that residence if he is going to take possession of that location. We are further asking for 1-day anger management, no alcohol, drugs, or weapons. And Ms. Coleman is present on the Zoom if Your Honor would like to hear from her.
Thank you, Ms. Falk. Ms. Bonstein?
Thank you, Your Honor. Mr. Trumbull is 30 years old. He's originally from Cleveland, Ohio, but he moved to Atlanta in 2016 to pursue his career in music. He does have three children with his wife, aged 2, 2, and 3. He did tell me that he would be able to stay with a friend or with his pastor if the court ordered no contact or that he could not return to the residence. We discussed that earlier. As for education, he does have a bachelor's in jazz piano from Central State University in Ohio, graduated in 2015. He does not have any criminal convictions and no prior violent arrests. He really doesn't have much in the way of money. As far as the contact, certainly be interested to hear what Ms. Trumbull has to say. If the court orders no contact, I would ask for a exception for child custody purposes. And if the court orders a stay away from the location, I would ask that he be able to go back with a police escort to get his items. And I believe that he was recommended for a signature bond through pretrial, and I would be asking for that based on his lack of criminal history.
All right, Ms. Coleman's on the line and would like to address the court. I will need for you to unmute yourself, and I'll have to swear you in. And
Hi, Your Honor. I'm at the hospital and my kids are here, so if you hear noise, I apologize.
okay, can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hands down, man. Thank you. What would you like to tell the court?
I would just like to say, Ernest, right now it's not a threat. I am in the midst of getting somewhere else to go, so I'm not going to want him to not be at home because our altercations are mostly over financial because we are trying to get more money. So I understand the situation. I don't want his bond to be so high, but if it is something reason that he can't make, then that's okay. I am going to be leaving, so just as long as we don't have the no contact, and if we can issue dates for him to see his kids, because I'm not going to stop him from, being a father, because he is a great father.
Okay, so Ms. Coleman, what I am going to do is
I'm sorry.
Okay. Right now, there's going to be no further contact between you and Mr. Trumbull. I am going to allow him to see his kids with third party, okay? And allow him to go back to the residence on one occasion to pick up any of his belongings. Okay?
Okay, and I won't be there, so part of that, I'll make sure I'm not there.
Well, it's my understanding that you're in the process of moving to a different location. Is that correct?
Yes.
Okay, so while you're there, he can't be there. But once you move to a different location, then he can return to the Cimarron Parkway address, okay?
Okay.
All right. So it's going to be a $3,000 signature bond through pretrial, a 1-day anger awareness class, no further contact with Ms. Coleman, stay away from the Cimarron Parkway address. He can go back there on one occasion with law enforcement to retrieve any belongings that he might have there at the present time. Once Ms. Coleman is no longer at that address, he can go back there with law enforcement to take possession if he chooses to do so. No drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Ms. Coleman, and you also, Mr. Trumbull.
Oh, thank you. And I'm sorry if it was too late. I didn't hear anything about anger management. I did wanted to request that for him. Like his mental. Like, okay. So
I ordered an anger awareness class. Okay.
Okay. Okay. Thank you.
You're welcome. Good luck to you, ma'am.
Thank you.
On position number 32, Darren Williams.
Good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You've been charged in case 22 CR 002152J with battery family violence. Is there a history, Mr. Howard?
7 total. Last was 2020 obstruction. Fleeing an officer. He's on probation in Houston County for robbery. 2015, they gave him 4 years to serve and 15 years probation. 2017, misdemeanor possession of marijuana. 2014, home invasion, first degree, dismissed. 2014, probation violation. Original charge was possession of a firearm underage. 2014, possession of a pistol or revolver by a person under 18, first offender. I think that's it.
All right, thank you, Mr. Howard. Ms. Falk?
Oh, hold on. 2020 parole violation. He did have that. All right, that's it.
Okay. Ms. Falk?
Yes, Your Honor. This happened November 13th of 2020. Officers responded to 6114 Ivy Chase Way. They met with Kelsey Estacchio, and I apologize if I have butchered that name, but it is EUSTAQUIO. First name Kelsey, KELSEY. She stated that the defendant, who is also the father of her 1-year-old child, struck her in the face and pulled her hair while they were arguing. The defendant then left the location. Officer observed a split bottom lip and swelling to the side of Mrs. Stacchio's face. Again, as the pretrial has stated, the defendant has, from our count, 2 prior convictions, one for the possession of pistol, 2015 robbery conviction where he's still on probation. He also has 3 probation violations, 2014, 2019, and the 2019 is notable because he got 18 months revoked on that probation violation, and a 2020 probation violation arrest. He also has an open case for obstruction and fleeing and eluding here in Fulton County. That is 20 CR 006005J. The state is requesting a $4,000 surety bond, no further contact with Mrs. Stacchio, a stay away from that location at 6114 Ivy Chase Way, and no alcohol, drugs, or weapons. We were able to speak with Mrs. Stacchio, and she did state that another incident had happened between her and the defendant in January 2022. And it was at that point the abuse got to the place where she could no longer stay, and she decided to leave the state with her family. She stated that she is afraid of the defendant because he becomes a different person. She stated he has been physically and verbally abusive with her in the past, and she is filing a TPO and does not want any contact whatsoever. She has gone so far as to not even wish to give her address at this time to our victim advocate and she does not want it publicized because she doesn't want him to know where she is. So we have some obvious concerns when our victim is this frightened. Even if it has been 2 years from the date of the event, there is indications that there was subsequent violence after that, and that is the cause for her wanting no contact whatsoever.
Thank you. Ms. Bronstein?
Thank you, Your Honor. Mr. Williams is 25 years old. He is from Atlanta and has lived in the metro Atlanta area his entire life. His whole family is here. His mom, dad, grandparents, uncles, cousins. He does have 2 children. Believe one with Mrs. Stacchio. He has 2 children. One's 2 years old and one is 3 months old. He did complete his GED and he works doing construction, and he's been doing that for 5 years. He did tell me that he recently found out about this warrant, and that when he found out about it, he turned himself in. I do believe that's something that the court should take into consideration, the fact that he did turn himself into jail when he found out about the warrant rather than run or wait for law enforcement to pick him up. I certainly believe shows that he is going to come to court. He does not make much money. We would be asking for a $1,500 good bond.
All right, it's going to be a $2,500 good bond. No further contact with the alleged victim, Kelsey, ESTAQUIO. Stay away from the Ivy Chase Way address. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Williams.
Well, Your Honor, since she moved, does he still need to stay away from that location?
Does he have a reason to go back to Ivy Chase Way? Is that his?
Jill, I'm not 100%
Okay,
if that's
well,
his
he can
residence.
go back. He can go back with law enforcement, and if she is not there, then if she no longer resides there, then if he wishes he can reside there. If she is there, of course, he'll have to just get his belongings. Okay.
Thank you.
All right. Are we completing courtroom 2 for this afternoon?
Yes, Your Honor. Just wanted to let you know that position number 8, Gregory Colbert, he has a waiver of appearance. So I from by PD Gant.
Okay.
Y'all do 33?
Okay, and that's all in courtroom 2.
And I was about to ask the same.
What about Stephon Young?
Yeah.
We thought he was upgraded. All his charges was upgraded.
That is what I received as well. I received a notification this
Yeah,
morning
saying
that
that
his
he was upgraded.
the DA transfer.
Okay.
What position is that?
33.
I will say the only case that we transferred was, let me just go back and check. I believe it was,
That was a female one. It started.
yeah, it was Tanika Turner's case. Was the only one, and I was the one who requested the transfer. So I'm not sure. I know I personally accused Mr. Young's case. There was no basis for an upgrade. I'm not sure why it was announced as such.
Okay, that's fine. The communication was wrong. We'll go get it different so he can be interviewed, okay?
Okay.
Thank you.
Thank you.
Okay. Yes, I've got him. I see you, Mr. Alfonso Colbert. We're going to address Gregory Colbert's case, but he's not going to be present when we address it as counsel has waived his appearance. So if you want to stay around with us, we will get to that directly, okay? Can you hear me, Mr. Colbert? Yes?
Yes, I can hear you.
Okay, all right. So we'll address that case directly, okay?
Okay.
So hang on for us. Who do we have at the South Annex?
Good afternoon, Your Honor. We have before you position 14, Ms. Kim.
Good afternoon, Officer Milton. I hope you're well.
Thank you, sir. I hope, well, I'm doing well, thank you.
Good afternoon, Ms. Kim. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002165J with driving under the influence of alcohol. Concentration is 0.08 or more. Driving under the influence of alcohol less safe, and improper or erratic lane change. Is your history, Mr. Howard?
First arrest.
Okay. Ms. Webb?
Yes, Your Honor. In this particular incident, John's, can you guys hear and see me?
I can hear and see you.
Okay, I don't know what just happened there. My computer just went blank. Okay, let's get back here. Excuse me, Your Honor. I don't know what just happened. I lost you guys somewhere. Okay, now I'm back. Okay. Yes, Your Honor. This particular incident occurred on April the 9th, 2022, where Officer O'Connor with his co-rider with the Johns Creek Police Department were patrolling around the State Bridge Road area when they noticed a 2022 white Mercedes GLC drift to the far left lane and cross the left fog lanes. The officer then began following and pursuing that vehicle and saw the vehicle drift again in and about of this lane. At a stoplight, the defendant did come to a stop, and when the light turned green, green, the defendant allegedly drifted all the way to the right lane around the Jones Bridge Road intersection, and the car entered the striped gore next to those left turning lanes, Your Honor. It was at that point that the officers activated the emergency lights and initiated a traffic stop. The officers did come and approach the vehicle, and the defendant was attempting to exit the vehicle without being asked by those officers to exit, but the officers did notice a strong odor of alcohol coming from that car. The officers questioned her about where was she coming from, and she told the officers a restaurant, and when they asked where she was headed, she said Duluth, and they noticed again that a strong odor of alcohol was coming from the defendant's breath. The defendant told the officers that she had a beer when they asked her had she been drinking during the evening, and when they asked her about how long that was that she had consumed a beer, she said approximately 2 hours. She was asked to exit the car, and officers noted that she actually had to hold the door and was stumbling while trying to catch herself when exiting the vehicle. The officers explained to her why they were concerned about her driving, considering her behavior at the scene, and asked if she would submit to a field sobriety test, in which she agreed. The officers noted that she was, based on the outcome of that test, intoxicated at the time, as her eyes were bloodshot red. She lacked smooth pursuit, and she showed 4 to 6 out of cues of intoxication, including she kept stop walking, swaying her arms, and couldn't really walk in a straight line. The officers then placed her under arrest, and the precinct did do a breathalyzer test that came back as 0.30 and 0.36, and she was charged, of course, on the lower of those two tests. She told the officers that she was allegedly told the officers, quote unquote, that she was glad I was caught, and that she did drink, but that she did not believe that she was drunk while behind the wheel, Your Honor. Albeit that this is the defendant's first offense, Your Honor, the state is concerned, and anytime there is a case of driving under the influence, that is a risk to the community, as we know that DUIs claim many lives every year in the state of Georgia. And for those reasons, we are requesting a $3,500 surety, no alcohol, drugs, or weapons, and no driving while out on bond. Nothing further, Your Honor.
Ms. Camp?
Thank you, Your Honor. Green Kim is 28 years old. She has been in the Atlanta area over 20 years. She has family here. Your Honor, Ms. Kim completed high school. She also has a bachelor's in design. She is currently employed at SK Imports. She has been in that position for the past 2 years as a designer. Today, we are disputing the allegations, and I would bring to the court's attention that Ms. Kim was cooperative. I am requesting a signature bond, being that this is her first arrest. We are opposed to the no driving conditions while out on bond. And if Your Honor is not inclined to grant a signature bond, I would ask for a bond of no more than $2,500. That would be $1,000 for the DUI, 0.08 concentration, DUI, $1,000 for the DUI less safe, and $500 for the driving lane change. Thank you, Your Honor.
Okay, it's going to be $1,000 for each of the DUIs and $250 for the erratic lane change, which makes it $2,250 good bond. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Kim.
How much was that again, Your Honor?
$2,250. $1,000 each for the DUIs and $250 for the lane.
Thank you.
You're welcome. Who do we have next?
Next, position 18, Ms. Lofton. Sit right there, please. Thank you.
Good afternoon, Ms. Lofton. I'm Judge Eric Morrow. This is the State Court Expedited, accusation calendar. You have been charged in case 22 CR 002158D with battery. Is there a history, Mr. Howard? You're on mute if you're talking.
8 total, 2021, theft by receiving felony. Possession of cocaine, possession of drug-related objects. That was in June. May 2021, identity theft, fraud, giving false name. It's open. 2019 FTA ag assault. Hold on for a minute. Ain't got no date on there. FTA possession of a knife during the commission. She was eventually convicted of ag assault. 2016 ag assault, FTA for simple battery. Got a battery that was non-pros from 2013. That's it.
Okay, Ms. Duncan, I think I've heard the facts of this a couple of times in Mr. Baughman's case, so you don't have to repeat all of them if you don't want to. Just if you want to highlight something, that's fine.
Yes, Your Honor, I want to clarify that the ag assault was an offered plea in 15 SC 139942, and there was an additional simple battery and reckless conduct negotiated guilty plea on March 9th, 2020, from the case 19 SC 168552. In addition to that, I see that the defendant has an open case 22 SC 180904 with 2 counts of identity theft and giving false name. This defendant's bond is currently set at $5,000 surety. Given the facts in this case, she did hit the defendant in the head with a glass ball and bite the defendant in this case. We would request that, given her history and the violent nature of these offenses, we request a bond, as I stated before, in addition to a stay away from the incident location, no further contact with the victim in this case, 1-day anger awareness, no alcohol, drugs, or weapons.
Mr. Coleman?
Your Honor, I will be requesting a signature bond from Ms. Lofton. Again, I remind the court at this time that these are just allegations against my client. She is 35 years of age, resident of Atlanta, Fulton County. She is a high school graduate, mother of 4 children, ages 3, 4, 5, and 8. Again, I'd be requesting signature bond, or in lieu of that, a low bond for Ms. Lofton.
All right, it's going to be a $2,000 good bond, no further contact with Tyrone Baughman. Stay away from the 355 Peachtree Street Northeast address. No drugs, alcohol, weapons while out on bond. Good luck to you, ma'am.
Thank you, Your Honor.
Next, we have position 22, Ms. Mateo.
Good afternoon, Ms. Mateo. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002164J with criminal trespass and damage to property and simple assault family violence. Is there a history, Mr. Howard?
Yeah, first arrest.
Ms. Webb?
Yes, Your Honor. This incident took place on April the 9th at 2765 Ashley Lane around 5:15 a.m., where the Alpharetta Police Department responded to a domestic dispute call and were met with Mr. Walter Lester, who is a homeowner. Mr. Lester informed the officer that he and the defendant share a child together, and the defendant came to his home and struck a window during a verbal dispute with the umbrella, causing damage to that window frame. The defendant at some point became enraged with with Mr. Lester and threw a water bottle at him, Your Honor. For those reasons, the state is requesting for the criminal trespass and $1,000 surety, for the simple assault, $1,500 surety, totaling $2,500 surety, with a stay away from that incident location at 2765 Ashley Lane. That's Ashley, ASHLEIGH Lane, Alpharetta, Georgia. No further contact with Mr. Walter Lester and his wife, Mrs. Lester. Third party contact with the party's minor child. No alcohol, drugs, or weapons, and 1-day anger awareness. Your Honor, the state is understanding that this is the defendant's first offense. However, the state is concerned with the risk of reoffending if that underlying domestic and familial issue is not resolved amicably between the parties. The state is concerned that another act of violence may occur. Nothing further from the state, Your Honor.
Mr. Coleman?
Your Honor, I'd be requesting a signature bond for my client. She is 22 years of age, has address in Roswell, Georgia. She went as far as the 11th grade. She is currently unemployed, so she has no money to post for bond. She is the mother of one child, age 1, and is currently pregnant. It's my understanding that the other alleged victim in this case, Stacy Lester, is not the wife of Walter Lester, but I believe his mother. Because this is her first arrest, again, I'd be requesting a signature bond.
All right, it's going to be $1,000 signature bond through pretrial for both offenses, which makes it a $2,000 signature bond through pretrial, 1-day anger awareness class, no further contact with Walter Lester, stay away from the 2765 Ashley Lane address, third-party contact for visitation with the minor children or child, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Mateo.
Thank you, Your Honor.
Your Honor, for position 18, Ms. Lofton, you said $2,000 what?
Good bond.
$2,000 good bond.
Okay, thank you. He said good bond, it's not a signature bond, Ms. Lofton. Okay, so you have to pay to get out. All right, next we have position 24, Ms. Mohammed.
Good afternoon, Ms. Muhammad. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002159B with simple battery family violence. Is there a history, Mr. Howard?
Second arrest. That was 2003 for theft out of Minnesota. That was a conviction.
Ms. Webb?
Yes, Your Honor. And this particular incident took place on April the 9th around 3 a.m. at 1465 Mid Broadwell Road. That's Mid Broadwell Road, BROADWELL, apartment 3311, Alpharetta, Georgia, where the Alpharetta Police Department responded to a dispute call. And Your Honor, the facts of this case are still being investigated by our office. But in this particular case, the defendant allegedly struck her live-in fiance with an open hand, resulting in that offense for a simple battery. The state is requesting a $2,500 surety with a stay away from that incident location and no further contact with Mr. Jeffrey Culver. That's Jeffrey Jefffery Culver CULVER. Nothing further, Your Honor.
Have you spoken with Mr. Culver?
Your Honor, our office did attempt to make contact earlier, and we were not able to make contact, but I'm going to double verify because sometimes we do have people that call back. So let me just double check while defense
Coleman?
proceeds.
Mr. Coleman?
Yes, Your Honor, I'd be requesting signature bond from Ms. Muhammad. Only her second arrest. Looks like her last arrest was almost 20 years ago. She is 39 years of age. The address in Alpharetta, Georgia is her apartment, so I would have an objection to a stay away. She is currently employed at Next Step Atlanta, mother of one child, age 11. Again, I'd be requesting signature bond. We object to any stay away since this is her apartment.
Is she married to Mr. Culver?
No.
Does he have
They're engaged, Your Honor.
Does he live someplace else?
I believe he is residing with her, but again, this is her primary residence. The lease is in her name. I would hate for her to have to leave her own apartment.
Okay, well, it's going to be a $2,000 signature bond through pretrial, 1-day anger awareness class. Since nobody has spoken with Mr. Culver as of yet, no further contact with Mr. Culver. I'm happy to modify that if somebody does speak with Mr. Culver or if he gets in touch with somebody. Given that I don't really know the circumstances regarding the Mid-Broadwell Road address, at this point in time, until someone speaks with Mr. Culver, she is to not go back to 1465 Mid-Broadwell Road, apartment 3311. She can go back to on one occasion with law enforcement to obtain any belongings that she might have there. If someone, I'm happy to modify this if someone gets in touch with Mr. Culver and he would like something different.
If she goes back to her apartment to get her belongings and he's not there, will she be allowed to stay?
If he is not a resident, if he doesn't plan on returning, then she can stay. But
So do you understand that, Ms. Muhammad?
Yes, I just, I take it, my daughter and my son, all of us are like in the surrounding of like 3 to 5 miles from the house. I work at and my daughter goes to school in that complex. I'm the main provider for both of my children. So I don't know how he would stay and I would leave when I pay all the bills. I have to take my daughter to school that's maybe 5 minutes from that residence. And I've been there for 7 years, Your Honor. And he just moved there maybe 8 months ago.
Okay, so my point, ma'am, is that, Ms. Muhammad, excuse me, is that you can't be around Mr. Culver at the present time, okay?
Can
So
he leave?
if he leaves, then you can go back there.
Okay.
All right, so, but he can't be there if, you can't be there if he's there.
Okay.
So if, so you can go back there, with law enforcement, and if he's not there, then you can stay, but if he is there, you can't be around him, okay?
Okay. So that happens, which one has to leave? Like, can I stay and he leave? I get his stuff and leave and me and my children stay there so we can go to school and work? I just want to be clear because I don't.
If he won't leave, then you can't be there is all I can say, okay?
Yeah, and you remember I told you, ma'am, since he has been there long enough to establish residency, you wouldn't even need to formally evict him.
All right, good luck to you, Ms. Muhammad.
Thank you.
All right, who do we have next?
Position 25, Ms. Engel.
Good afternoon, ma'am. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002146Y with driving under the influence of alcohol, less safe, and improper erratic lane change. Is there a history, Mr. Howard?
No.
Ms. Falk?
Yes, Your Honor. This happened yesterday at 12:35 a.m. Officers stopped Miss Neo on Old Alabama Road and Haynes Bridge Road. Officers stopped the vehicle after they observed her swerving over into the center lane, almost striking a concrete divider and then swerving back into the center turn lane. Officers approached the vehicle, could smell the strong odor of alcoholic beverage coming from the defendant. Her eyes were watery and bloodshot, and the defendant stated she had 1 cup of wine while eating out with a friend. The officers conducted field sobriety, and she showed 4 out of 6 clues on the HGN, 5 clues on the walk and turn, and 3 clues on the one-leg stand, and also showed 2 clues on the instructions for the one-leg stand. So did not perform well on the field sobriety testing. Implied consent was read. She declined a breath sample. Although the defendant does not have a criminal history as far as the GCIC is concerned, she actually has quite an impressive driving history. She has 12 traffic violations since 2007 and 4 since 2018. So I backdated about a little less than 5 years to give Your Honor an idea of what we're talking about. So she had May 2021, unlawful use of a wireless device out of Doraville Municipal, August 2021, Georgia serious disqualification, August of 2021, speeding 65 and a 45, Duluth Municipal, August 2021, following too closely, Atlanta Municipal. So these are all different offenses within just the year 2021. So for those reasons, we are asking for a $5,000 surety on the DUI and a $500 surety on the improper lane change. We're further asking that she not be permitted to drive without a limited permit and that she have no drugs, alcohol, or weapons.
Okay, who's representing? Whose client is this?
Sorry, I thought this was position 25.
It is.
Oh, I'm sorry. Yes, I got my numbers mixed up. I am representing Ms. I'm sorry, I don't know how to pronounce her last name.
She's on mute.
No.
No.
Yes.
Right. I apologize, Judge. So Ms. No is 46 years old. She was born in Vietnam, but she came to Atlanta in 2003. She is a US citizen. She is married, and she has a 10-year-old son. She works as a hairstylist and has been doing that for 18 years. But she does not have much money. She's certainly has ties to the community, lack of criminal history. We would be asking for a $1,000 bond. I understand what the state was saying about the case, which is why we're not asking for a signature bond. But as I stated, with the lack of criminal history, and Ms. Ngo's lack of money, that's what we're asking for.
All right, it's going to be $1,000 good bond for the DUI, $250 good bond for the erratic lane change, total of $1,250 good bond, no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Ngo.
Next, we have position 31, Ms. Wall.
Good afternoon, Ms. Walls. I'm Judge Eric Morrow. Good afternoon. This is the State Court Expedited Accusation Calendar. You have been charged in the case 23 CR 002154G with cruelty to children in the 3rd degree. Is there a history, Mr. Ngo?
It's a second arrest. Last was 2002 obstruction, NOD.
Ms. Falk?
Yes, Your Honor. This incident happened back on August 6th, 2021 at 1989 Sand Creek Drive. The victim in this case, Kiera Monet, and that is Keiarra, Monet, like the painting, was 18 at the time of the offense, and she stated that her mother, the defendant, accused her of stealing her weapon and then punched her in the right eye and her lips in the presence of her younger sister, Santasia, Santasia Ashford, who was 11 at the time of the offense. The officers did observe bruising to her eye. They actually notated that her eye was so swollen she was unable to see out of it, and that there were injuries to her lips as well, and that resulted in her transport to Grady Hospital for treatment. As we stated, as pretrial stated, she had a 2002 obstruction. However, due to the nature of the incident, the fact that there were children involved, the fact that Ms. Monet is almost a child herself, we are requesting a $2,500 surety bond, no further contact with Ms. Monet, and stay away from 1989 Sand Creek Drive unless Ms. Monet is no longer at that residence. And we're further asking for no alcohol, drugs, and weapons and a one-day anger awareness course.
Okay, so Ms. Monet is related to Ms. Walls how?
It is the child of Miss Walls,
Okay,
according
so
to the police report.
It's her daughter.
Correct.
Okay, so if the daughter got punched, why isn't she charged with punching her, allegedly?
She is charged with punching Miss Monet.
Oh, all I have down is cruelty to children in the 3rd degree on my calendar.
No, there is a battery as well, Your Honor.
Okay.
And that may have just been an issue with the way the case was filed down, but it's a battery and cruelty to children in the 3rd degree.
Okay, yeah, I wondered why. So it's a battery, family violence.
That is correct.
And
cruelty to children in the 3rd degree. And I apologize, I did leave the bond out for the cruelty to children. That would be a $500 bond. So it'd be a total of a $3,000 surety bond.
Okay. Now, Ms. Monet, does she, she's 18 and she's the daughter, does she have the resources to provide for herself at the 1989 Sand Creek address without her mother?
And we are not clear on that. We did leave a message. We also sent a text message, but we did not receive a response from the victim in this case.
And Your Honor, I was going to state in a minute that Ms. Walls owns that home. Her daughter is not on any type of lease, is not on the mortgage. It is a house that Ms. Walls owns. Since this was 8 months old, I'm sorry, I'll make my argument in just a second. I just wanted to let
I'm with you now, Ms. Weinstein. Go ahead.
So Ms. Wells is 41 years old. She has lived in Atlanta her entire life. Her whole family is here. mother and 3 children, a 12-year-old, a 19-year-old, who is the complaining witness in this case, and a 26-year-old. She is a high school graduate and works as an operations specialist, building repair. It's a generally customer service job. If the building needs to be repaired, she figures out how to get that done and who to hire. That is a part-time job, however, so she doesn't make that much money. She's been doing that for 6 years. There is, as pretrial noted, a lack of criminal history. As I stated, this is a house that Ms. Walls owns. Her daughter, and this incident happened 8 months ago, back in August of 2021. Since then, Kiara came back to live with her mom, but she is not on the lease, not on the mortgage. Her mother owns the house. So she willingly came back to live with her and has been living there for several months now. So I would not ask for no contact like the state asked for, and certainly not a do not return. This is her house that her adult daughter is staying her with. She can certainly go live on her own, but I don't see how she could stay in the house that her mother owns without the owner of the house. So additionally, I believe that she was recommended for signature bond pretrial, so we are asking for that.
All right. Anything further, Ms. Falk?
Yes, Your Honor, only to say that obviously our preference would have been to find out what the victim's living status is, where she is currently, what her feelings about the issue of contact are. But we unfortunately have tried to make contact and we're unable to have contact. It doesn't seem like anyone at this point has had contact with our victim, Ms. Monet. And so I understand the court's concerns, I understand the defense concerns, but we also have concerns here, Your Honor, about a 18-year-old who was punched so hard in the face by her mother that her eyes swelled shut. So those are our concerns too.
Okay. Well, there are lots of concerns in this case. I think what I'm going to do is have a social worker go out and visit also until somebody hears from Ms. Monet. I don't know what else to do because I don't think that it's an 18-year-old. She's an adult, yes, but she's 18 years old. And she can't maintain this household with a 11-year-old child in it also. So it's going to be for the battery, a $2,500 signature bond through pretrial, for the cruelty, a $500 signature bond through pretrial, 1-day anger awareness class, social service visitation for wellness check, no further violent contact with Ms. Monet, and no drugs, alcohol, or weapons while out on bond.
And Your Honor, 2 things. What was that second, what was the bond on the cruelty to children?
500. So it's a total of 3,000.
So 3,000 SOB pretrial.
Correct.
And I also did check Odyssey, and both the battery and the cruelty to children were filed. They are in Odyssey. I'm not sure what happened or why they didn't make their way here.
That's fine. Yeah, we've got it down. Okay, thank you, Ms. Falk. Good luck to you, Ms. Walls.
Thank you. Your Honor, what was her bond amount?
It's going to be a total of a $3,000 signature bond through pretrial, $2,500 for the battery.
3,000 signature bond through pretrial. Okay. All righty. That's it from the side.
It's both charges through signature.
So we are.
I'm sorry, Your Honor. She wanted to know if it's both charges, a signature bond?
Yes, both charges.
Yeah. All right. Thank you for everything.
Okay, we'll see you tomorrow.
Okay,
Your
bye-bye.
Honor, Ms. Gant indicated she has spoken to Mr. Young.
Okay. So hold on. So we're going to Mr. Young?
Yes, position 33.
Okay, so we have a waiver for position 8, so we're gonna do that. And then 33, what are we gonna do with Mr. Young? Oh, there he goes.
Right, we are ready for him. Ms. Gant has.
Okay, so we'll go to Mr. Young. Good afternoon, Mr. Young. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. You have been charged in case 22 CR 002153A with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
First arrest. He has an FTA warrant out of Gwinnett for a traffic offense. That's it.
All right. Ms. Falk?
Yes, Your Honor. This incident occurred at 6854 Fireside Lane. At approximately 4 p.m. yesterday, officers were called out there to a physical dispute. They spoke with Miss Destiny Gonzalez and her child, O.Y., who is a child that she shares with the defendant. They were sitting outside of the residence at Fireside Lane when the officers arrived. Ms. Gonzalez stated that she and the defendant had gotten into a verbal argument regarding her leaving to return home. The defendant stated she wasn't going anywhere, and Ms. Gonzalez replied telling the defendant he was a bomb, like a ticking time bomb. The defendant became upset and attacked her, striking her with a closed fist on the left side of her face. And when Ms. Gonzalez managed to pull herself away from the defendant and went to pick up their child, O.Y., the defendant attacked her again while she was holding their child. At one point, he dragged her across the floor. Officers did observe scratches to her legs and her swollen jaw, which were corroborating evidence with her statement to the police. And although the defendant has no previous history, the state does have concerns that this not only happened in the presence of a small child, but that the attack did not discontinue once the mother had the child in her arms. For those reasons, we are requesting a $3,000 surety bond, no further contact with Destiny Gonzalez, that is Desteny. Gonzalez is 2 Z's, Azalez, and a stay away order from 6854 Fireside Lane, no alcohol, drugs, or weapons. We are amenable to third party contact with the child, O.Y., and we are asking for 1-day anger management.
Have you spoken with Ms. Gonzalez?
Let me just double check, Your Honor. I know that we did try to reach out to Ms. Gonzalez, but let me check and see what the status of that contact was.
I'll come back to you, Ms. Falk.
Yes, Your Honor.
Okay, Ms. Gant?
Thank you, Your Honor. Mr. Stephen Young is 21 years old. He has community ties in the Atlanta, Georgia area, including his mom. He again shares the child with Miss Destiny Gonzalez. Mr. Young completed high school. At this time, Your Honor, he is unemployed. I did have the occasion to speak to Miss Destiny Gonzalez. When I spoke to my client, he provided me his mother's telephone number, Miss Aisha Phillips, and she gave me Miss Gonzalez's number just for clarification. Miss Gonzalez informed me that she wants to continue having contact with Mr. Young. Again, Mr. Young denies the allegations. This is my client's first arrest. He does not have any prior history whatsoever. He is recommended for a signature bond. We are opposed to the stay away. Mr. Young advises me that that is his residence and that Ms. Gonzalez does not live there. And I would ask that Your Honor grant a no violent contact order. And if the court is not so inclined, then a third party transfer between children. Thank you, Your Honor.
Ms. Falk?
And Your Honor, I just want to point out that, and we did look at our information. We were not provided enough information in the initial warrants that we received to be able to make contact with Ms. Gonzalez. However, I did point out the time of this incident for a reason, Your Honor. We are at the start of today's hearings, we were less than 24 hours. We are right now just over 24 hours from the time of this incident. And so we do have some concerns that there hasn't been a sufficient cooling off period at this point between the parties to just allow for there to be no further violent contact.
And Your Honor, if I may just add, my client does not have any violent history whatsoever. And if we are operating under the assumption that these are in fact allegations, my client is presumed innocent. And I would ask that we go along with Ms. Gonzalez's wish, as I had the luxury of speaking to her along with my client. Thank you.
Mr. Colbert, you do realize that we can all see you, don't you? Okay, we're in court. All right, so I'm happy to have you here, but you know, you have to be respectful, okay? Thank you. Mr. Young, it's going to be $3,000 signature bond through pretrial for the battery, $1,000 signature bond through pretrial for the cruelty to children in the third degree. Makes it for a total of $4,000 signature bond through pretrial, one-day anger awareness class. At the present time, no further contact with Destiny Gonzalez. Says if Ms. Gonzalez does not live at that 6854 Fireside Lane address, you can return there with law enforcement. If she does live there, then you can return there with law enforcement to retrieve any belongings that you may have there. You can have third-party contact with your minor child for visitation and their drugs, alcohol, or weapons while out on bond. Okay? Good luck to you, sir.
Thank you, Your Honor.
All right, so let's go. I think that does it for courtroom 2. Doesn't look like anybody's around him. Let's go back to position number 8. I believe I have a waiver in that case. Is that right, Ms. Gant?
Yes, Your Honor, Mr. George Colbert.
Right, Gregory
Colbert.
Colbert. Yes,
Gregory
he's charged with criminal trespass. Is there a history in that case, Mr. Howard?
And Your Honor, I do apologize for interrupting, but I would like to discuss this case along with number 5, position 5 in a breakout.
Okay. Mr. Alfonso Colbert, how are you? Are you related to Gregory Colbert?
Yes.
How are you related to him?
Unfortunately, he's my brother.
Okay. So we're going to discuss your brother in a breakout room. I'm happy to have you there if you'd like to join us. Okay. So we'll take you into the breakout room along with us. So let's see, Ms. Gant, Ms.
Hey,
Falk.
let me give you the history, please.
Okay.
I'm gonna do that. All right, 25 total.
Okay.
He got several FTAs. Last arrest March 25th this year, shoplifting. He's on probation for burglary in the first, terrorist threats, battery, family violence. Has an open burglary in the first, ag assault, 2 counts of trespass, cruelty in the third, 22 SC 180514. He's also out on pretrial from a previous case. That's it.
And Your Honor, Mr. Alfonso is the victim in this case.
Oh, Mr. Alfonso Colbert's the victim? Okay. Before you go, Mr. Howard, could you give me the history on position 5, Mr. Brown also?
Oh, he got 136 total, so
Okay.
yeah, he got a lot. And then that spans from California to a whole bunch of other places.
All right, we're good. Ms. Falk, given that Mr. Colbert's a victim, do you want him in the breakout or not?
Your Honor, I would prefer to do the breakout without Mr. Colbert just at this time, and then we can hear from Mr. Colbert after the breakout is concluded.
Okay, so if you hang out for us, Mr. Colbert will be back with you. So Ms. Gant, Ms. Duncan, Ms. Falk, myself, anybody else we need in the breakout? Okay, now can you put us in a breakout room, please?
What you laughing about? Just all the stuff he got going on. All the stuff he got going on.
Hey, mute your mic.
fine. Let's see, is Mr. Colbert there? Yes, Mr. Colbert. I understand that you've been having some difficulty with your brother. We are going to, as a condition of his bond, have him undergo a mental health evaluation. So he's going to have to do that. He'll get a good bond of $1,000 and needs to stay away from you and your home as a condition of his bond. Okay.
Okay.
All right. You got any questions for me, Mr. Colbert?
Now, what's a good bond?
That means it's a surety bond. It means that he's going to have to, that he's not getting a signature bond. He can't just sign himself out. He's going to have to either go through a company, a bonding company to get himself out, or he's going to have to pay it.
Okay.
All right. Any other questions for me?
No, are they going to keep me in contact with the case? Because I feel like,
you have the solicitors here, and they will let you know when the next hearing is going to be. Okay.
Okay.
All right. Any other questions?
A probation violation. I ain't gonna get into that.
Oh, and I don't know anything about that anyway, so that's fine. All right. You have a good afternoon, Mr. Colbert.
All right. Thanks.
You're welcome. All right. Are you all ready to go over the calendar? I take that's a yes.
Yes.
So, yes. You're ready, Ms. Lewis. I know we're all tired.
We're so tired we can't get the words out, Your Honor.
Whenever you're ready. All right. You want me to go over the calendar? Okay.
Everybody hear me?
You're on mute.
No.
Well,
Yeah, and we can't hear you.
they can't hear you for some reason.
Can they hear me through your computer?
Hey, Katrina, make sure that microphone is turned on in front of you. Somebody might have turned off.
Can you hear it now?
Can you hear me now?
No, her Zoom is.
It's still low.
I mean, barely.
You want to come take a seat up here?
No, you just gotta put your thing on.
All right. Okay.
I think her Zoom is muted.
Okay, can y'all hear me now?
Okay, yes,
Yes.
yes, we can hear you.
You can hear me real good.
Yeah.
Okay. All right, everybody. The reset date is going to be April the 26th. It's going to be April the 26th. I guess I might have to.
So just turn that mic off that's in front of you now.
Yeah, no, that's what I thought. Okay, that's better. Okay, reset date is SAP April the 26th, 22.
Is that better for you all?
There's an echo, but Miss Lewis, just power through. We're good.
Okay. Position number 1 is a $5,000 SOB through the jail. It's reset further notice. Position number 2 is a $3,000 SOB through pretrial, reset further notice. Position number 3 is a $5,000 SOB through the jail, reset further notice. Position number 4 is a total of $4,000 SOB through pretrial, reset further notice. Position number 5 is a $1,000 good bond, reset for SAP. Position number 6 is a $3,000 good bond, reset for SAP. Position number 7 is a $5,000 SOB through the jail, reset further notice. Position number 8 is a $1,000 good bond, reset SAP. Position number 9 is a $2,000 SOB through the jail, reset further notice. Position number 10 is a total of $3,000 SOB through the jail, reset further notice. Position number 11 is a $2,000 good bond, reset SAP. Position number 12 is a $4,000 good bond, reset SAP. Position number 13 is a $5,000 SOB through pretrial, reset further notice. Position number 14 is a $2,250 good bond reset for SAP. Position number 15 is a $500 good bond reset for SAP. Position number 16 is a $500 good bond reset for SAP. Position number 17 is a $1,000 good bond reset SAP. Position number 18 is a $2,000 good bond reset SAP. Position number 19 is a $3,000 split bond, $1,500 a good bond, and $1,500 is a SOB through the jail. Yeah, did I get that? I know it was kind of quick, but that's reset for SAP. Position number 20 is a $2,000 good bond. That's going to be set to the next competency calendar, which is going to be April the 28th. Same announcement on the next case, but the bond is $2,500 good bond. Position number 22 is a $2,000 SOB through pretrial. Reset further notice. Position number 23 is a $1,000 SOB through the jail. Reset further notice. Position number 24 is a $2,000 SOB through pretrial. Reset further notice. Position number 25 is a $1,250 good bond. Reset SAP. Position number 26 is a $5,000 SOB through the jail. Reset further notice. Position number 27 is a $1,000 good bond. Reset SAP. Position number 28 is a $1,000 good bond. Reset SAP. Position 29 is a $1,000 SOB through pretrial. Reset further notice. Position number 30 is a $3,000 SOB through pretrial. Reset further notice. Position 31 is a $3,000 SOB through pretrial. Reset further notice. Position 32 is a $2,500 good bond. Reset for SAP. Position number 33 is a $4,000 SOB through pretrial. Reset further notice, and the add-on is a $1,000 SOB through the jail. Reset further notice. Any questions?
Yes, could you clarify the contact provisions for positions 1 and 2, please?
The what again?
The contact provisions for positions 1 and 2.
1 and 2, I have, it's a $5,000 SOB through the jail, no further violent contact with Shannon Miller. Stay away from the incident location, and they may have a one-time return for law enforcement officer to retrieve personal items. No alcohol, no drugs, and no weapons, no firearms. And position number 2 is no further violent contact with the victim, no alcohol, no drugs, no weapons, no firearms, 1 day anger awareness.
For position 1, I do not believe that there was a stay away in place. This is Anderson.
It was one at place. Y'all just said
Yes.
amend the no violent contact. I mean, no contact of violence. So y'all amending that part too?
No, I just wanted to know about, was it violent or non-violent? I put NFC and I wasn't sure.
Number 1 was amended to no further violent contact, but that was the only thing that was amended at the time. Y'all didn't indicate to stay away, so I would take the stay away.
I believe that we did want to not have a stay away.
No, it was just no further violent once we heard from the victim. I think the only concern I had was originally it was no further contact. So I didn't know which one was the right one that I had written down. Nothing else was changed according to my record. Judge, we can't hear you.
I'm sorry, I changed it to no further violent contact, and I meant to change the stay away provision also. So
That's my understanding.
it's not going to be a stay away from the Landrum Drive address. So if we can make that change, Ms. Lewis. Anything else?
Nothing further.
If not, I appreciate it. Thank you all. Y'all are troopers.
Right, have a good evening.
Thank you. Have a good night.
We'll see y'all tomorrow.